start with a very brief homily as to health and safety issues. If we have a fire or an emergency or an earthquake, we shoot out the door at the back of you and meet at the State Sale House. The toilet facilities are out that same doorway that you entered, and otherwise, cell phones off. You'll see us, or me, referring to a cell phone that's just looking at the X, and otherwise goes off, and we're underway. Can I just say, though, that unfortunately today we've been very accommodating to everybody right up until today. But today we're going to be watching times because I have to get a flight to Auckland, which means I've got to leave here at 1, and otherwise I'm staying overnight. So look, we've pre-read everything, and so if there's succeed, there's a possibility. Thank you, Mr. Anderson.
Thank you. I thought you were going to hear somebody else first, but
Mr. Curry first, is it? Yes. Sorry, thank you.
No, that's fine.
There was somebody from yesterday. So, Mr. Curry, are you available?
Will be on your screen in 1 moment.
Okay. Thank you. We do have documents from Mr. Anderson. Good morning, Mr. Curry.
Good morning.
There we are. We've got you now, thank you. And we've got your submission in front of us, which we've read. So we're in your hands.
Cool. Kia ora, thank you for that. Alan Toka Ingoa, I'm here. Really just, I'm not a technical expert on the IPS, but I'm going to speak about 3 things that are concerning a lot of young people in our community. And some work that we've been doing on it. So first is of the lack of an overarching vision and objective for freshwater in Otago. The second is on Te Mana o Te Wai and what the Manahira process has taught us. And the third was in the work we've been doing over the past 2 years on the nitrate impacts of communities in Otago and how the regional policy statement can turn this around. So, I mean, first of all, as a lot of submitters have said, I just want to amplify, especially like Forest and Bird & Co, I want to amplify that, we know that the FMU specific visions have no overall objective, and they're presently inconsistent and lacking in many ways. And without an overall vision for freshwater in Otago, the MPS FM 2020 will not be achieved and the environment will continue to be degraded. So this is really priority number 1 for the submission, is just that we need a really clear vision for freshwater in Otago that's clear, that is before 2040 or ideally 2030. We know that the history of environmental policy in this region is a history of delayed and missed targets by neglect or by design, and but it hasn't delivered the urgent policy interventions we know are needed, and that's why the environment is in the state of crisis we have right now. We need to pull every lever we have hard, and we're not going to do that until we have a overall vision for freshwater in Otago. And I think Karunaka o Otago put this, extremely clearly when they said their first preference of Karunaka is to have an overarching vision for key values that apply to all FMUs. And so I think we've really made it clear that the really important thing is the specific overall vision. I think we've also learned a lot from the Manuhira Kia decision here of delay and delay and delay. And I think we've obviously seen it here to a certain extent. And I just would like to play a quick video of a bunch of young people about the Manuhira Kia and why we've been so concerned about the process. I'll just jump on.
Kia ora Otago Regional Councillors. We've been watching what you're up to.
We know you're about to make an important decision on the flow of the Manuhira River.
We want to make sure that you make a choice that safeguards the future for all of us, following the recommendations of Kaitahu Ki Otago to increase the Manuhirakia's flow.
The river is important to us for so many reasons.
It can be a healthy, thriving ecosystem that benefits us all by those nutrients being absorbed by our soils or eaten by our fish.
We've watched the irrigation lobby push hard to maintain the status quo.
But as it is, the river is degrading.
And this paves the way for more intensive forms of farming that aren't sustainable for Otago's rivers or the climate.
The direction we have to go in is clear. We have to take less from the environment and give more back.
For the fish that swim, for Mahika Kai, for the water we drink, and for the tamariki that play in it, put the awa's health first.
For the resilience of our natural environments and communities, put the awa's health first.
Your proposal to delay the decision making that you've had years to make is weak leadership. you've delayed already, only a few years ago.
How many times have we heard that there's not enough information and that we can't act now, it's too hard? These are the lines that delay action that urgently needs to happen now.
We're tired of stale decisions by leaders, and we need a staunch departure from the status quo.
We simply leave it to us with an even worse situation.
You're in positions of leadership for a reason, to help lead our communities through challenging but important decisions.
In the notice of motion, you say you have begun our journey in thinking about ways in which we can assist in non-regulatory processes. Are you serious? We don't need vague, wishy-washy discussion. We need a substantial increase to the river minimum flow.
Protecting the Manuhira Kia River is climate action. It means we can thrive more now and be more resilient later when we need to.
A healthy environment supports healthy communities, and healthy communities support healthy farming.
Make the decision to be the adults in the room. Make the decision that future generations can celebrate, not vilify.
The more water you leave for the river, the more faith we can have in you.
That you're not going to leave us with some messed up region with unsustainable land use that we have to make even harder decisions about.
So, Otago Regional Council, make the right decision, because after all, we are watching.
Really clear objectives and a really clear specific vision. We know that places like the Manuhira Kia and other decisions we made within that vision, and we made with this really clear objectives. So the Manuhira Kia is again one example of, because we know it is us versus irrigation companies. We know we sat here and we watched Fonterra, Ravensdown, Dairy NZ, Balance, all here come here and make these submissions. And we know that their fundamental vested interest is in profit and continuing to exploit the whenua. And so I think we have to be clear that it is ultimately us. It is the people and it is the environment, and we need to really diminish the influence that these corporations are having in our planning and in our processes. And we need to be talking about where it goes there. And obviously, it's about putting Te Mana o Te Wai first, so that all the other objectives in the RPS are informed by the priority to take care of water and to keep it healthy. And we urge you to consider cumulative effects of pollution, such as intensive dairying and too much synthetic nitrogen fertilizer, rather than simply in each individual catchment, because we know that what happens upstream affects people, plants, and animals downstream. So, it's about applying the precautionary principle. It's about putting a levy on it. And I'd just like to show one last video. But before I go to this, I'm just going to say that we, over the last couple of years, I've been working with communities across Otago and some beyond Otago as well on nitrate and nitrate cancer risks that have been causing to communities. So we made a little video about this and about the work that's been having. And the reason I'm going to show you this video today is because these communities are literally dying of cancer and other reasons, and synthetic nitrogen fertilizer and too many cows that's what this plan's about, right? We can change the way we manage our land. We can change the way the policy statement and the visions we're upholding, and that's why I think this is quite relevant. So I'll just jump on there as well.
I wonder, Mr. Curry, can I just interpolate there? Have you filed a submission in relation to the freshwater process?
Was that in the last couple of months?
Yes.
Yeah, I think we did. Yeah. So maybe that's more relevant.
The reason I raise it is just that we're unfortunately, as a matter of law, not able to look at quality or quantity issues in this hearing today, but we can and are directed to in the freshwater process. So I suspect that your video that you're about to show us probably relates to quality issues, which we can properly look at in the next hearing process, which is likely to occur in the end of August, early September.
Okay, thank you, Andrew. Just to be clear, yeah, it's about the nitrate impacts of water from synthetic nitrogen fertilizer and the importance of a synthetic nitrogen fertilizer phase out. Is that not something that can be done in this plan, a synthetic nitrogen fertilizer phase out?
No, look, it can be in terms of the regional policy statement, absolutely.
Yeah.
Unfortunately, as a matter of law, and it's very hard to sort of explain to you why, it's got to this stage, but the High Court has directed that we are not able to look at quality or quantity issues in respect of water. That has to be dealt with by what's called a freshwater planning hearing, which will be occurring at the end of August. It'll be the same personnel, which just makes it a nonsense, but we stuck with that, I'm afraid. And so we would welcome you to come back at that hearing, and we'd be happy to look at your video then in relation to nitrate effects. But because it's a quality issue, we can't take that into account today.
Okay, so that sounds good. That's fine. Thank you. But yeah, I mean, ultimately, I think that we've seen in the phasing out synthetic nitrogen fertilizer, and lowering cow stocking rates. Yeah, my understanding is, I mean, we know we've watched what ECAN's done, and we've watched ECAN's motion go through on, not go through in the end on levies on synthetic nitrogen fertilizer. And so I guess ultimately, I just encourage you in this process or in other processes to consider what are the really key drivers that are harming our environment. And yes, setting the vision is number one. And then ultimately, I think for us, it has to be about synthetic nitrogen fertilizer and phasing it out. We know that's what's enabling cow numbers in our communities. We know that's what's polluting nitrates in drinking water, causing 40 deaths every year. And we know that's what's preventing our nature from restoring. So I just encourage you to consider that as well as the vision. So that's all I have to say. Thank you so much.
Thank you very much, Mr. Curry. And the visions, strangely enough, was something that we do have to address in this process. So you've been right about that. And we look forward to hearing you when you come back. Thank you.
Kia ora.
Thank you. Thank you. So, hang on. That's better, isn't it? Yeah. So, we've got about an hour and a quarter. Is that right?
Yes, although if you can cut that down.
We probably can.
Yep.
We probably can. I think it's just really a question of where we're going now. I've circulated some submissions. I've got next to me, I've got Maria Callahan, the planner, who will be giving evidence, and I've got Rebecca McGruth from Port Otago. There was as the panel identified, there was a mistake made with Kevin Winder's evidence that really the essential parts of it had been retained. There were just some extra bits put in that shouldn't have been. Essentially, he's not able to be here this morning, but any questions in terms of his evidence can be answered by myself or by Rebecca. So hopefully that'll satisfy it. But his evidence is largely concerned with operational matters and the importance of the port. And I didn't anticipate that probably the panel would have too many questions about that. Can I just ask one thing? I'm pleased to see that the same panel is working in respect of both sides. Are you going to release, are you going to wait till you've had all of the hearings before releasing a decision? Is that?
Look, the thrust of the submissions we've been receiving from people has been to adjourn these proceedings until we hear the freshwater proceedings, and we haven't made a formal decision on that. But can I say that it sounds like pretty good common sense, and particularly when whilst we're facing the dilemma of two sets of proceedings with the same people, same brain, and obviously the aim at the end of the day is to have an integrated document.
Yeah, well,
logic would dictate that you what's been suggested to do is follow.
And of course, the benefit of that from Port Otago's point of view is that while the Supreme Court have said their decision is in hand, I mean, we've been waiting for a year for it now. Mm-hmm. So I anticipate that I said freshwater's answer in August. So with a bit of luck, we'll have that decision, because it would sort of be a bit of a sad thing for Port Otago if we win the battle of the Supreme Court, but lose the war because you're obliged to deal with the Court of Appeal decision. If we're successful, and I mean, who knows what's going to happen there. Obviously, it's a bit of turmoil because the normal expected time is 3 months, they say, for decisions. 6 months for decisions. The Supreme Court, 3 months for the other courts, and they've already been 12 months. So we just wonder what's going on.
The Chief Justice has a role of jumping on other judges throughout the country if they're over the time, expectancy. So
exactly.
Can I just say that in terms of your legal submissions, we obviously will listen carefully. That Ms. O'Callaghan, I think, ran through pretty carefully the background to those cases.
Sure.
Thank you.
Yeah, I think the main thing I want to do in terms of it is just really talking about, I talk in paragraph 3 about Alistair Logan's submissions, which are correct, but with a gloss on them, because I think that if you have a look at Mary O'Callaghan's evidence, right at the back is the plan, which we should have a nice coloured plan. Yes. Right. So if you have a look at that plan, you can see the channel running down alongside the Aramoana split marsh, which is in purple, and then running down through there. And that area around the mouth of the harbour is the area that we have the conflict in terms of the ability for the port to operate and the protection of various matters. So you've got salt marsh, and then you have the other areas that are shaded there. And so far as the port is concerned, the current issues are likely to be around salt marsh, but there is also the 3 disposal grounds. The first one is Shelley Beach off Aramoana. It is really a sand, it's really to keep the beach stocked, that one. There's not environmental issues, particularly in relation to that, because there is a mole which helps the channel. It actually stops the sand on the beach, so that's why that is used. Then you have the Aramoana dumping ground, Hayward's dumping ground, and then there's another one, AO, which is a bit further out, all of which have implications in terms of various things that occur there. And so that's why the port has real concerns. Now, if I go to what I refer to at 1.3a and make the point that while avoidance policies don't require prohibited activity status, and that's definitely true, they still have that effect unless there is a permissible countervailing policy that's not subject to the avoidance policies. And because where the avoidance policy is, if that's the only relevant policy, then there can't be a rule that permits an activity that has effects that are contrary to it. And it's not possible to obtain consent for an activity that has effects contrary to it, unless the effects are minor or temporary. So when you've got minor or temporary adverse effects, it can be contrary to policy, but not otherwise. And that's the case when the rules come in, and so the policy becomes really important. One of the issues that is important, though, in terms of what's said there, is that while the avoidance policies don't require prohibited activity, if there was a prohibited activity that gave effect to an avoidance policy, it might raise the question of it would probably remove the ability to have temporary or minor adverse effects. That's not a matter for that's not a matter that you're considering in relation to policies. And while the activity status can't be prejudged at the policy statement level, the current state of the law is that avoid means avoid, and rules must accord with the policy. So any activity that has effects that impinge on avoidance policy in a way that's more than minor can't be permitted whether or not it's prohibited. And even if Port Otago is successful on appeal, then that will remain the position where there's no enabling policy that can be relied upon to create an exception for the general prohibition effects of the avoidance policies. And I talk about this later in my submission, but I'll talk about it now. I mean, the real difficulty with the King Salmon decision and the port submission that was made to the Supreme Court is that policies are not rules. And a policy can have effect as a rule. If there's no countervailing policy, then it has effect, but it's not a rule. And we all know in our lives that sometimes policies which otherwise would be really important and would run your life, there can be other circumstances where they have lesser significance. So the example I gave to the Supreme Court is that you can have a policy of a work-life balance, in other words, being sensible. And then you can have a policy of getting your work done on time, and ideally you work, both those things happen. But when the Supreme Court tells you you've got a case in 2 weeks' time, what happens to your work-life balance? Because the policy, that might have been seen as more important generally, but in the particular circumstances of that case, the other policy takes priority because you've got to get that done. And it's the lack of flexibility in terms of countervailing policies that isn't really identified in King Salmon, and it doesn't take allowance for the fact that a policy which would be totally dominant in one set of circumstances may be quite different in a different one. And the question, King Salmon, was to do with the establishment of a salmon farm in an unsuitable site, and it was clearly unsuitable. But the issue that would be raised there is if it was important to have an aquaculture site, and the policy required it, and that was the only site that was available, the factors might well have been different in terms of the way in which the policies were raised. So I'm just really explaining that to give you the background of where we are looking at. And so the sorts of problems that the court is going to face is, I mean, the main one is the Aramoana salt marsh issue, because I've given an example in paragraph 2.3, and you've got the cruise ships coming into Dunedin. They're very important to Dunedin. They're very big, the cruise ships, and they've got to slow right down to get round the Harrington Point bend. You can see the bend there. And the difficulty in terms of it is the risk of, because they're going so slowly, they catch the wind because they're so big, and there is an element of risk in terms of the bigger the cruise ships are. And consideration has to be given as to whether the channel be widened to accommodate the big cruise ships. And that would involve some eating into the Aramoana salt marsh. And it's not to say that the consent should necessarily be given, but what the port is seeking from the Supreme Court is the ability to argue that the cruise ship trade and the importance of it, if it is required, is in fact a more important policy than the removal of a small amount of the salt marsh. So that's the policy issue in the way that it's looking. Whether they can argue that or not is really dependent upon the. It's really dependent on what the Supreme Court says, and we're in their hands. An interesting side effect of the way in which the King Salmon works is that if the channel was to collapse alongside the salt marsh, Port Otago is entitled to repair it. It's emergency powers. It can go and do it under section 330 of the Act. I've referred to this in paragraph 2.4. They can repair it immediately, but then they've got to get a resource consent. Well, it's possible that they wouldn't be able to get a resource consent. So you've got a direction in the Act to get a resource consent and the impossibility of getting one, which is part of the difficulty that was highlighted in the Supreme Court. So if I go to 2.6, our submission in relation to this issue was that the interrelationship between the policy and the conflicting policy should be spelled out. And even if it is just simply to spell out what the Court of Appeal says, but if the Supreme Court's available, then we've got option 2. And in Mary's evidence in the schedule that she's done, she's provided 2 options depending on what the Supreme Court says. It may be that the Supreme Court comes back with something similar, and certainly we would welcome the opportunity if you want to hear on the implications of the Supreme Court decision, if it is something other than an issue one way or the other. But so what happens is that if we haven't got the Supreme Court decision, then the activities that are contrary to the policies where they're essential for the efficient and safe operation of the port, and that's obvious, or essential for effective communications. And then the exceptions are they have a minor or temporary adverse effect on protected values. So temporary or minor, and that's permitted by the Court of Appeal. And then the fourth additional provision, which needs to be added, and Mary's going to talk about that in her evidence, is have effects that can be avoided through adaptive management, because the Court of Appeal have said that adaptive management is a means of avoiding adverse effects. And I just want to talk to you a little bit about that. Now, what adaptive management means is that you have a lot of uncertainties in terms of the coastal marine area, and you can model behaviour, but the question is whether in fact what's going to happen is exactly as modelled, and the risk that it isn't, and particularly where there is a risk of adverse effects, is something that would could preclude an activity that otherwise is permitted by adaptive management. And what you do in adaptive management is that you're constantly monitoring to see that things are behaving as expected or better than expected. To some extent, that's happened with the big dumping ground at AO in terms of the channel deepening. There's a series of monitoring to see what happens to the suspended solids. And whilst I think it's fair to say they've generally behaved in the way that was expected, in fact, there's been less movement towards the coast than expected, so it's been a bit better. But of course, what happens is that if it is worse than expected, then things have to stop, because they can only continue so long as it's behaving as expected. And so it's a sort of a method of ensuring that the predicted effects are going to happen actually, and it provides a great deal. It's been used really successfully, I think, in terms of the work within the harbour and work outside the harbour. It also means that there are days when there can't be particular work done because of the other coastal conditions. So once again, because there are general coastal conditions that might result in sediment in the water. But so adaptive management is an important rider to that. But the importance of spelling out the relationship is that the policy makes clear that Port Otago is entitled to argue a particular use or a particular activity should be permitted where it has minor or temporary effects, and protected values can be avoided by adaptive management. And so an example of that is the putting of a beacon on the Armwana salt marsh. That's only got really minor effects, you're just putting a beacon there. And so there's no argument, and the Court of Appeal have accepted that's fine, irrespective of the protected status of it. And at 2.9, I've just asked that you wait as long as you can, and I'm confident, but I might be wrong, that we should get a decision by then. Now, I'm just going to briefly talk about the other matters that Mary's going to talk about. She's identified the commercial port should, I suggest, be specifically included within definitions of infrastructure. It is an important piece of infrastructure, and the fact that it's got to be inferred, it would be better if it was there. There's some issue in terms of the relationship of the integrated management objectives and the policies with the direction in section 5, and Mary suggested alternative wording. Environmental limits and limits throughout the plan is a bit of a problem, because what is a limit? I think that's may well have been accepted as an issue, but it appears in the port thing within limits, and that's just creating an element of uncertainty. The point is that limits really relate to rules rather than to policies. And if you're thinking in terms of the fact that a policy weight can depend on a particular circumstance, it's a bit incongruous to have a limit in terms of a policy. If you had a limit as to how long you were going to work, but something had to be done, it just illustrates the conflict between the concepts. There's a lack of certainty in the identification of highly valued natural features and landscapes. The concern that the port has is that outstanding and and a void, and that's quite clear. If in fact there's going to be, well, there's nothing to stop a policy statement protecting everything, even right down to the level of mildly important things. It has flow-on effects irrespective of what it does. And the importance, I suggest, is that you need to have a methodology to identify what it is that is being looked at once you get into these areas. Because if it's going to be something that has the power of an avoidance policy, there needs to be care given, and particularly if you're looking to extend the protection that the coastal policy statement gives. I mean, Elsa Logan's quite correct. You're not limited by the policy statement. You can, the policies can provide much greater protection, but of course it's going to have effects. And in terms of the port, that effects could potentially impinge on its operation. Regionally significant surf breaks. I just want you to think about that issue. I mean, the port has experience with the national surf breaks. They're there. And what is significant about the surf breaks that are within the that are affected by the port's operations is that they're also created by the port's operations. So the nationally significant surf break at Aramoana is created by the channel. The waves hit the side of the channel by the heads, and that creates the surf break. And the other surf break is affected by the dumping ground at Haven Point, and in fact created by that. And the port's been very proactive in working to ensure that the surf breaks function well, and there's good cooperation in terms of the port and the surfing interests to ensure that the way in which the dredgings are deposited, in fact, have maximum effect in terms of having the surf breaks. But that's the port's experience. But if you start to map regional surf breaks, it is going to have unexpected consequences in terms of what's going to happen if they're protected. And the question that I raise, and while this is outside the issue of the port's particular interest, it falls within the knowledge that the port's had because of what it's been doing. If, for instance, there was going to be given a regional protection to the surf break at St Clair, what effect might that have on the ability to carry out remedial work as a result of coastal erosion or global warming? I mean, there's been talk about work being done at St Clair, and as soon as you start to do something, it can have an effect on something else, and it would be counterproductive if a regional surf break was given a degree of protection that prevented remedial work being done in terms of global warming. So I just sort of flag that as an issue, that it's not, once it's given, it's not to say that it can't be recognised in some way, but if it's going to be given the same degree as protection as the national surf breaks, you can't do anything that is going to interfere with it. That's the problem that arises with it. Mary talks in G, in F, the restructured policies related to manage ecosystems and Indigenous biodiversity in the coastal environment, and she talks about the proposed clauses don't adequately set out the criteria for evaluation, and this is an issue that comes back to that issue of how actually you're going to work these things out. In G, unnecessarily complicated to have an area subject to coastal hazards and natural hazards for existing activities. And the recommendation is that the no increase in risk test is changed to no more than a minor increase. And it might not seem as a huge alteration, but the wording becomes really important because just as avoid means avoid, no means no. And so we're getting into absolutes. and suggests a reconsideration in the relationship between provisions in the infrastructure chapter and the coastal environment chapter. So I've skimmed through that pretty quickly, but hopefully I've got the essence of where the port's coming from. And
indeed, Mr. Anderson, the other benefit the report's had and you've had is that other council have been addressing very, very similar issues. So the actual port-related aspects are new and different to us, but a lot of the avoid and other issues have been traversed. The adaptive management one is of interest in that I've been raising that over recent weeks, and I take it that in the port's submission, and I haven't looked back at it closely, but I take it that adaptive management was, or some reference to a provision of adaptive management was made, or is that a question better directed to Mr. Keller?
I don't know if it was specifically made. I mean, it essentially is permitted by the Court of Appeal decision, so that it's really the point is that using adaptive management is can be seen as avoiding. So that's the issue. It's not that it is something special in terms of a particular thing. It is just spelling out that avoiding can include using adaptive management to avoid. And that's what the Court of Appeal made clear in its decision. It's not what the port is wanting, of course. It's just the fallback position if we're stuck with the status quo, because adaptive management doesn't come into it if it becomes a question of the policy things. So it's what's seeking there is that whilst it might be seen as unnecessary to put that in, because what is being sought is no more than what the Court of Appeal says, but it just makes it clear to everybody where you're sitting, because this has been such a contentious issue for so long, that spelling it out either way I suggest to be quite helpful in terms of people can look at the policy and say, well, hang on, that's what it means, and that's what the port's entitled to do, and that's they're entitled to apply for, because it doesn't give the right to do anything. It just says that in these circumstances it can apply. And if it's just thought that if it's spelt out now, that might ease things as we go down the chain in terms of the various other things, because the next step in terms of the rules are going to follow from the policies. And if you can look at it and say, well, that's what does and doesn't happen, it's helpful in terms of formulating the rules.
All right, I have no further issues that I want to raise, but there may be other questions from other commissioners.
Can I just say one more thing in relation to that? Because what it also does is it makes it clear that it can't be, for instance, a prohibited activity to extend the channel, if in fact, or to do those things, if it can be done in a way which has only minor or temporary effects. Because a rule that is a prohibited effect would absolutely prohibit the activity as opposed to the effects. So that's another reason for having it there, because it is signalling that there is, from the top of the policy, it's signalling what the court has said, and this is the way that it is to be applied. And also any questions on Kevin Winder's.
Yeah, thanks. Now, my only question just followed up from what the chair was just talking about around adaptive management. I had quite a lot of involvement in Littleton Port's redevelopment post-earthquake, and including the capital dredging, and the adaptive management proposed there was actually, I thought it was pretty advanced, and it seems to have worked really well. But are you aware of any sort of cases where there's adaptive management, or situations where adaptive management's been defined? And this is a question, I'd be interested in Ms. O'Callaghan's view on this down the track too, because it's something that I think I've seen adaptive management as a term or as a concept bandied around in a lot of different situations, and in a lot of situations where I don't think it is adaptive management. And I think
That's right.
Whether if we're going to head in that direction here, we need to actually be defining it in some way, either through the policy or through the definitions. Are you aware of if that's come up in any of the cases you've looked at?
Not as such, but I think the point, I think it's the wrong issue. You see, the point is that what you are saying is that we can avoid adverse effects by adaptive management, because this is what we predict is going to happen. This is how we can ensure that it would happen. And the difficulty is that if you don't have adaptive management, then the possibility that that might not happen is an adverse effect which could kill the project. So that it is basically, when you're proposing adaptive management, you've got to satisfy whoever it is you're proposing it to that there are not going to be adverse effects, because the adverse effects which could happen are counted sufficiently by the adaptive management techniques. And when we had the channel here, it was quite interesting, because the end result of the adaptive management process was that the various experts were hot tubbed by the planning judge. They were both put in there together, and they had a discussion and came up with something between them, which was the adequate monitoring that they were satisfied would ensure that it worked. But the point about adaptive management is that there's a mechanism in place to ensure that there are no adverse effects, and work stops immediately if there are adverse effects. That's what we're talking about in terms of it.
Nothing.
No, thank you. I think mainly from Mr. Callaghan.
Right.
I just have a question about what's not here. and that is whether there was any of this has any impact on kaitahu or kaitahu interests. I mean, I don't see it here. Whether it should be or not, I don't know. That's partly my question. Are there any of the issues you talk about here that are impacted on kaitahu values, for example?
Well, yes and no. I mean, I think that the kaitahu values kaitahu do not want any further development in the harbour. But on the other hand, kaitahu have been very understanding of the need for the port to operate safely and efficiently. So, for instance, the deepening of the channel, which was something that would, on its face, would be contrary to what kaitahu would want, was in fact supported because of the necessity of doing it. And of course, that has a minor effect on the cockle beds, which are really important. And also it had an effect on the Aramoana salt marsh. So I think that the answer is that the port does not do anything unless it absolutely has to. The other issue that was particularly relevant to kaitahu was the dumping in the disposal grounds in A0, because whilst there was only a small chance of silt ruining the fishing grounds, obviously that would be a major disaster if it happened. And that emphasised the importance of the monitoring regime to ensure that the silt was not going ashore, and the adaptive management. So that was a situation where if adaptive management had not been permitted, then they wouldn't have been able to be there, because whilst the risk was small, the consequences were significant, and it emphasises the importance of it. But so anything to do with the harbour is important to kaitahu. There's no doubt about that.
I imagine
the reality is that when we're talking about policies, we're really just talking about right at the top of the chain, and port still has to make its case for an expansion if that's what it needs. It doesn't mean it's going to get it, but it's not precluded from doing so. And that's what we're talking about here, is the ability to make its case, and the kaitahu interests would be part of what's relevant if that happens.
Okay, thanks very much.
Thank you, Mr. Anderson. So, yeah.
Good morning, can you hear me okay? Now, I've just written up some notes that I'm going to speak to today, but I'm happy to take questions as I go or at the end, just whatever suits. So obviously I've got my evidence in chief and I've just spent a bit of time trying to catch up on the 6 months or so, which has elapsed since I prepared my evidence and everything that you've been hearing from the officers in particular in relation to the matters that are contained within the evidence. So it's been, I might not have got it all right in all parts because there wasn't a collated version of all the officers' recommendations, but I have managed to collate one of those myself to try and work that out. So I just start off by talking about the key issue of interest to the port, which is obviously how the port policy reflects case law understanding and anticipation of the Supreme Court decision. So I talk about the appropriateness of the directive policies which require the avoidance of all effects on environmental values and how these integrate or don't with the policy that gives effect to policy 9 of the NZCPS. And in my evidence in chief, I suggested 2 amendment options to the EIT Transport Policy 23, which is the one that we've tagged a similar outcome to that which is sought on the previous RPS. Now I note that neither of the amendment option appears to have been adopted by the recording officer based on summary notes that I've reviewed. I would have expected that the version reflecting existing case law understanding could be adopted by the recording officer in the interim period ahead of the Supreme Court decision. That is my option 1. But that has not occurred. The Transport Chapter Officer, Mr. Langman, states that the drafting options that I presented are helpful, but didn't go so far as to form a view on either of them. The issue is the current case law is relevant to policy 9, and that includes.
I think those next 2 paragraphs we can take as read, and I think if you go down to where you set out below the refinement of the wording, right?
Yeah, so look, we're just picking up on the fact that in the evidence in chief, I set out the policy that was sought through the previous regional policy statement. I've got that in paragraph 26 of my evidence in chief, and unfortunately I just missed off a reference to the adaptive management that's come through as being confirmed by the Court of Appeal decision. And so I've suggested some further wording below that just jots that in there. So all of my track changes that I set out start from the position of the officer's recommendation. So unfortunately I've used the same colour as the officers, but they're my changes in the red, not the officers. So yeah, so I'm suggesting removing the reference to these limits, specified limits, and I'll come to that further, and then putting in paragraph 4, which sets out what I believe reflects the current case law. So in the appendix that I've updated and attached to these notes, I've also got the alternative version, which is what's been sought through the Supreme Court case. So really highlighting in relation to what's in policy 9, the need for the activities to be essential for the efficient and safe operation of the ports, and for transport, other transport connections, other words that are taken directly from policy 9 of the NZCPS, and then legitimising minor, temporary and adaptive management as parts of avoiding effects. So per the King Salmon and the Court of Appeal decision. So just you were asking before about adaptive management. Look, certainly I think adaptive management is well understood by the planning profession. It wouldn't be hard to come up with a definition if that would be helpful to the panel. There's plenty of understanding around that, what that is. Take some guidance from you if that would be useful. In terms of my experience with adaptive management, really the key case I've been involved in is the port's reconsenting of their disposal grounds, and the adaptive management in that case was in respect to the surf breaks. So I know there's a lot of focus in the commentaries around the landscape and the biodiversity and the natural character values, but the surf breaks are also subject to an avoid policy. And as Mr. Anderson said before, the surf breaks are in part created by the port's activities. So the process there is, those effects happen over a long period of time. They're not instant effects, and there's a comprehensive set of conditions that set out how that will work and what will happen if the monitoring, which is coastal process seabed type monitoring to record whether things are changing, and then an engagement process with the Surf Breaks Protection Society and the local surf group, and agreeing that it's going okay, and if it's not, then adapting where they're putting the sand on the mound that is the disposal ground. So helpful again, the port will be able to provide copies of those conditions for that surf break consent, if that would be helpful to just get your head around how it works in the context of the port's operation. That was consented probably about 7 or 8 years ago, I think, something like that. So and also just I think that was the questions around the adaptive management. So I'll just move on to the next one on page 2. Just looking at the limits qualifier that's appearing obviously in policies that are of interest to the port, but throughout the plan, and the uncertainty as to which provisions apply. So caveating the enabling provisions with the term limits, in my view, is uncertain and is not the right term in any case. This is used in the reporting officer's wording of policy 23, which I've just commented on, and other objectives and policies through the plan. For example, it has been added into Coastal Objective 3 by Mr. McClellan's hearing summary amendments. Now, a limit is generally numeric or specifies a point to stop something, and if you're part of the freshwater panel for this policy document, or it will become apparent, but probably more so when the regional plan starts getting underway. Certainly I'm involved in the freshwater planning process in the Wellington region. I'm working on the plan change for that. So I have a good understanding of what a limit is. It's generally numeric or specifies a point to stop something that needs to be clearly narrated for the specific context. As Mr. Anderson said, a limit cannot be a policy. So the inclusion of reference to unspecified limits in a policy is quite uncertain in my view. As you know, the port's activities have the potential to conflict with environmental constraints. That was the map that Mr. Anderson showed you that's appended to my evidence in chief. We have locations of Indigenous biodiversity, natural character, landscape and surf breaks. Limits are not described in the policy statement for these values at all, nor are they possible to be set at a regional level. With my wording that I've recommended above for policy P23, in the event that the port's unsuccessful in its Supreme Court challenge, just to be clear, this is the wording that I've put on the page here as if it's unsuccessful. The concern is resolved with that because I've removed the reference to limits, but that remains clear in the regional policy statement where it's used elsewhere. Constraints would be a better word, but really the policies should just be read as they are. They don't need to all necessarily cross-reference because the document needs to be assessed in the whole. Likewise, I reiterate my suggestion of visual coastal icons or symbols, which was part of the submission, to add clarity as to which provisions apply to activities within the coastal environment. when the policy statement was notified, there was a significant amount of duplication between the coastal chapter and the other chapters. And so it's important to know where the other chapter provisions do not apply to the coastal environment, so that, you know, in a minor consent for a wharf extension, such as the one I've just done for the cross wharf at Port Chalmers, it's minor maintenance work that we don't have to go through and assess hundreds of policies and multiple documents. So that's what we're trying to achieve there, to make that clear. And obviously when you have duplication, there's a risk that they conflict. So this suggestion hasn't been adopted by the officers. I'm not particularly sure why. In my view, this method is preferable and a valid alternative to all of the written exclusions. However, even with the written exclusions, they would add a lot of interpretation, certainty and value. I note, for example, that the text exclusions that have been now drafted for every individual objective and policy in the natural features and landscape chapter now. You know, that's a lot of exclusions, and then there's other chapters where it's been done differently. I think the hazards chapter might be that example. I'll get to that shortly. So just by way of example, the icons are used in the Wellington Regional Plan to assist with what's a coastal provision and what's not. In that case, I think they're used for coastal marine areas, so what's part of the regional coastal plan. This has got a slightly different construct that they're dealing with coastal environment, which includes a bit of the land, and that's fine. It's just a case of trying to avoid the duplication here and be clear which is a coastal environment applicable provision and which isn't. Now, just turning to definitions, you'll note in my evidence that we had some initial concern when we made submissions about whether the Dunedin facilities of the port, so those located within Dunedin City rather than Port Chalmers, were captured by the regional policy statement as nationally significant infrastructure. So a couple of things had happened that the officers had recommended that that the nationally significant infrastructure is incorporated as part of the regionally significant infrastructure, and that assists in parts of the plan policy statement. And then we've revisited the reference to the Civil Defence Emergency Act definition. It seems to come up everywhere. It doesn't make a huge amount of sense why referencing another act is the way to describe a nationally significant port, but anyway, that's what is used. And the issue there is that I'm just asking that the panel satisfy themselves that the reference to a port company that was based in Port Chalmers is adequate for all the ports facilities, which, as you've heard, we've got provisions at provisions at wharf facilities at Ravens, Bourne, at Dunedin, and obviously there's other bits of ports, sort of navigational infrastructure, beacons, etc., out in the harbour itself. So, so that's the point there. Also, I've made a note about there's a lot of terms about infrastructure that could be relevant to the port from time to time, and the policies deal with upgrades and new infrastructure differently. I've set this out in paragraphs 90 to 93 of my evidence, and I have suggested some definitions which would assist with interpretation of this in consent processes, but also in subsequent plan development. Without it, I can be confident that there'll be lots of uncertainty and arguments between applicants and consent authorities as to what constitutes an upgrade and what's new infrastructure. So I'm just trying to prevent that and make it more simple. Just looking at coastal environment and biodiversity. So there's been a change made by the reporting officer to policy CE P5. Now that one, so this one, it does actually appear to have followed my evidence, and I think it actually does resolve the So, sorry, I just got to find the provision. Yes, CEP5, so that's this is a version that was attached to Mr. McClellan's opening statement for the coastal environment chapter. So he'd recommended deleting G&H from subclause 1 and moving that to subclause 2, and I think that resolves the risk that the same critter or bit of vegetation or whatever could end up in both the policy 11A. I'm talking about policy 11A in the context of the NZCPS because that's really the port's interest. You know, that they're not going to end up in both categories. The, you know, must be avoided, the avoid significant adverse effects one. So I think that's resolved that particular part of the biodiversity concern, provided the panel adopts that. And then the other, all of those other ones have now got exclusions throughout the chapter. So yeah, so that one's interesting. If you look at P7, eco, if I just take you to eco P7, this really got me very confused when I was trying to prepare for this, but in the offices, so this is in a red change, so this is probably in the supplementary version. So it's got the P7 is about coastal biodiversity, and it's got an exclusion to the policies eco P3, P4, P5, and P6. But unless you look at P7, you don't know that eco P3, 4, 5, and 6 don't actually apply if you're in the coastal environment. So again, coastal icons would be really useful, but that's a very different way of doing the exclusions than what's been done on some of the other chapters, in that they're all sitting in one policy rather than on each provision, as that's been done on the natural landscapes and features. So it just makes navigation of the document and risk of, you know, so lawyers getting excited about why they're being differently one day. If we don't have a little bit more, and I think the icons would, you know, give the belts and braces certainty as to what's intended. So yes, I'm just saying that exclusion is not entirely obvious on first read if you start with policy eco P3, for example. Okay, so now I'm on to policy CEP1. Now that's a policy in the coastal chapter that's got a whole lot of cross references to other chapters. So Mr. McClellan has set out that the planning standards, I think, require the reference in the coastal chapter to all the other applicable chapters. So I accept that and agree that there is at least some content in all those other chapters that do appear to be relevant, albeit large parts of them are excluded. So I think that's okay, subject to the removal of the reference to natural features and landscapes, which has been completely removed, having relevance to the coastal environment, other than the appendix on how to assess them. That's appendix 9, which is at the back of the name. So just on that natural features and landscapes, the officer's recommendations add all these individual exclusions to each objective and policy through the chapter. That's the blue text in the Mr. McClellan's summary statement on landscapes and features, natural features and landscapes. So that's they're all okay. In my view, that's removed the duplication. I remain concerned about the methodology for including highly valued landscapes versus outstanding ones as the appendix, which sets the methodology for how to identify them, which does apply to the coastal environment as well. It doesn't distinguish between those that are highly valued and those that are outstanding. So that creates uncertainty. And I also note that highly valued landscapes are not required to be mapped at all by the New Zealand Coastal Policy Statement for the coastal environment, or indeed for any land-based areas. The Section 6 requirement is around outstanding. And so I've retained my earlier recommendation to remove all references in the policy statement to mapping items that are not required to be mapped by order documents, particularly because there's no methodology for distinguishing between them. In addition, I note that effective CO3 is inconsistent with the NZCPS. And I'll just take you to that one. We're back in the coastal chapter now, so we've got a policy, an objective that says basically that all areas of natural character, natural features and landscapes are protected from inappropriate development. Now that's patently not consistent with, Section 6 or the NZCPS. So that needs to change, and I've put recommendation in my appendix for that. That's setting a way higher bar than what is required, and therefore has massive consequences in terms of being able to enable activities that have been provided for in higher order documents such as ports and policy 9, and undoubtedly other matters such as renewable energy, transmission lines, all those other ones that are similarly protected by high order direction. So just turning to natural hazards. So Mr. McClellan comments in his natural hazards opening statement in relation to my suggested solution for avoiding duplication between the coastal hazard consideration and the risk-based assessment regime for other hazards. And I've just put a quote there, and he's raised that he's concerned there could be non-coastal hazards within the coastal hazard areas, such as fault lines. So in my view, the reporting officer appears to have accepted that the risk-based assessment and policies are not helpful or applicable to the coastal hazard situation, and that there is benefit in avoiding differing hazard policy regimes applying to a single location. So I'm envisaging that the coastal hazard areas are going to be mapped as such, the coastal hazard areas, and they're going to be managed in accordance with coastal hazard policy. That's indeed what the regional policy statement requires of the council and the district plans. His remaining concern appears to be that non-coastal hazards could also exist where coastal hazards are present. I accept this situation could arise, but I consider that the dominant issue in such locations will invariably be coastal hazards. And accordingly, my opinion, coastal hazard policies could easily be amended to provide for this extra amendment to support the previously requested amendments to those policies. So I've just added that there to policy 10, and then I think all my other amendments can stand and is in line with what Mr. McClellan was trying to get to. So the remaining suggestions I made to policy NHP4 and NHP7 were not addressed in Mr. McClellan's natural hazards opening statement. These are actually key issues that I've addressed them in 108 to 110 of my evidence. It's important that the council doesn't set a zero risk policy expectation for projects planned as hazard adaptation works. I've had considerable involvement in such projects, and there is always some minor offsite, adverse effect arising, and it's a case of needing to be able to get on and do some of those works. Otherwise, we'll end up in a situation that we've seen up in the Hawke's Bay and Gisborne without being able to do any hazard protection works. So there will be offsite effects. Not every hazard, not everything can be reduced to zero in that event. So it's completely inappropriate to set a policy that expects that, in my view. Regionally significant surf breaks. The reporting officer disagrees with my recommendation to remove clause 2 of CE P7 on the basis that the document doesn't So I've requested that it be removed because the regional policy statement doesn't provide any direction for how regionally significant surf breaks should be identified. And he refers the hearing panel back to the section 42A commentary. And there he noted that research is being undertaken to develop a methodology to identify these surf breaks. I just comment that presumably this is now advanced in the intervening time and some criteria may be available now. However, without this being included in the notified proposed RPS, there's limited opportunity for key stakeholders such as the port, councils, etc., to be engaged on and file any submissions on the methodology for safe areas. There must be mapped in the plans. The risk that is evident with current policy and method is that mapping methodology will be developed outside of any public planning process. There is no engagement, therefore, on the surf break mapping method, which is not suitable, especially given that there is no higher order direction requiring regionally significant surf breaks to be mapped in the first place. My other concern is the future mapping of such surf breaks is likely to be in locations where it will conflict with other essential activities that are subject to higher order direction and will be likely to be taking place to ensure the future sustainability of coastal environments and the use of these locations where possible. And I've just noted that they could frustrate coastal hazard adaptation, the port's own adaptation to sea level rise, potentially, to name a few likely conflicts. Presents an extra hurdle that is likely to be conflicting with these activities and therefore the need to provide for ports. So in summary, I've updated, on these notes, I've updated my Appendix 1 and just explained how my changes are shown. Now I'll just run through these quickly. There's a couple that I brought to attention. So I've just shown an example of the icon that I'm suggesting be added to the policy document. The next one I set up my definitions for operation and maintenance, upgrades and new infrastructure, which will help with the understanding of those policies and future plans to give effect to those. Putting in the definitions now will enable the plans to avoid having these debates down the line and a regionally consistent approach, particularly between district and regional infrastructure, and bearing in mind that there is significant, obviously, infrastructure that need to be upgraded, etc. In the Dunedin area with roads along the coast, and usually you need both district and regional consents for those. The next one is just recommending the removal of the highly valued landscapes throughout the document. The integrated management, there's some submission points there that I haven't really reiterated, but really just pretty straightforward changes that represent really better integration. The use of the fact that there is use and development of the resources needs to be acknowledged in that long-term vision, and that safety needs of people is essential as well, and a key issue for the port. It's not just about the health needs of people. The issue is these wordings really come from the MPS freshwater, and they don't apply suitably for the entire environment. They're definitely what's required for freshwater, but they're not the statutory direction for the wider environment. Natural character and features, that's that coastal environment policy that I talked about before, the need to just have that refined back to outstanding as per MPS, as per section 6 of the RMA and the NZCPS. Noted that I'm happy with policy 1 per Mr. McClellan's recommendation.
So, Carolyn, I just think that we're getting into such detail now that it's covered in relevance, and particularly like that, make sure we get opportunity for questions.
Sure, there's just one correction that I need to make. Yep. If you go over to page 8, I've got a reference under CEM2, defining other areas. I say delete table 2 in full, that should be table 1. And that's because that includes, well, that's predetermining where these areas are going to be, and it's a list of a whole lot of locations that need to be identified. It's predetermining that they are in fact, such values, and the evidence suggests that some of them are medium to high anyway, which is not what the policy is seeking. But I'm happy to take the rest as read.
Thank you. Yeah, that particular table, I think we had discussions about that earlier because in the past hearings, because that numbering is just wrong. I don't think it's your fault.
Oh, right, okay. Well, I'm just looking at the version today and it seems to be table 1, so I don't know where I got table 2 from.
Oh, it's table 2 in the
It's table 2.
Oh, right, okay.
Yeah.
Oh, thank you. I thought it was going crazy.
Okay, no, that's right. So, look, I'll open the for any questions.
Yeah, thanks, Ms. O'Callaghan. I don't actually have any specific questions. You've covered all the points that I had in your summary, so thank you.
Yeah, thank you. Your summary was very helpful. Just getting my head around some of the issues you phrased. Like the limits qualify. I think what you're saying there is like the policy framework sets the outcomes you're seeking. Limits should be defined by rules and they can be defined in any way by a rule. So you don't see them appropriate as in a policy framework sense.
Correct.
Just reference to them, because you really should be identifying what the outcome's going to be.
Yeah, well, the limits there's no limits in the policy statement, so referencing them is, a plan user is going to go looking for these limits and they don't exist.
Yeah, and it's really a matter for the low water plans, so I would have thought.
Well, it's predominantly a term that's going to be used in freshwater plans.
Yeah. Your definitions of what I found them quite helpful. Where did they actually come from in relation to the infrastructure? Have you used these before? The operation and maintenance upgrades and new infrastructure definitions?
Look, they're my own work, but they are informed by some definitions that I was involved in through the regional plan mediation for the Wellington regional plan. So they've been modified from those because the context was quite specific to some rules, but the concepts, what was agreed. So that process, and obviously I can't disclose all the mediation details, but that process involved parties, same sort of parties that you'll have here, infrastructure providers, forest and bird, all of the usual parties that will be, so it's they've been agreed to, but it's a different context here because it's a regional policy statement rather than a regional plan, but it's an opportunity to short circuit it potentially.
Yeah, in relation to CP5 and the landscapes, those issues, I think you've highlighted issues that a lot of other people have highlighted. And that table you just talked about, table 1, table 2, whatever it is, I would have thought that would be ultra-virus. It could be bringing that into this plan like that, because it wasn't in there, and then suddenly it's just a big wide list. I'm not sure around the legality of that. Whether Mr. Anderson had a view on that. I'm not sure how you can do that without actually going through the process.
Well, if there was submissions seeking those specific additions, then my view is
I'm not entirely sure if there were actually.
Well, if there's not, then that isn't legal.
It's something we have to look at. But the only other question I had was in your two options, which I'm find.
So in the appendix, it's on page.
Yeah. So understand option 1, which is if you start with avoid policies. Option 2, if you're not stuck with the avoid policies, there's been quite a use of the effects management hierarchy throughout this document. I'm just wondering whether that would be a better approach and forward, if it could be worked somehow into that. Have you considered that at all?
Not specifically, but the
issue would be,
because but then it leads to I mean, you'd have to be comfortable with offset and compensation if it goes that far. I'm not sure. I haven't looked at your avoid your effects hierarchy in this particular plan. Does it go through to offset?
Yeah, and that's where I was wondering whether it would be useful for the port, because most of the Windows evidence I found quite interesting around some of the things that you're doing with surf breaks
Yeah.
And I understand what you're saying about regional significance. I've had
It's-
this discussion before, but some of those things seem to be an offset or a compensation, actually, even rather than a direct effect of what we're doing. Some of the work decisions.
The port, I'm not aware of the port going down the offset or compensation line. I mean, look, of course, it would be better for the port if there was that option. But certainly the port's been, comfortable working with mitigation in the past. But yeah.
I think I read quite a bit about what the port's sort of doing around assisting surfing almost in other areas. And it may have been in the wrong context because it might have been the wrong evidence, but I just wondered whether that was a better approach than what you promoted here.
Can I just answer that? I think the difficulty is that it wasn't seen that offsetting is permitted by King Salmon when you breach the avoid policies, and to some extent that is being considered by the Supreme Court, because the case was heard together with the East-West motorway case, and there has been a bit of offsetting, I gather, there, which they've sought to bring within the framework. So if offsetting was allowed, then that would certainly be good. But the perception has been that, and certainly so far as Port Otago is concerned, it's tried to get through the crack that's there in relation to the contrast in the policies, rather than perhaps having a full-scale attack on.
Yeah, I guess I'm probably on a slightly different track because it's the policies this relates to is avoid in the first instance, and if you can't, then you drop down, whereas you're stuck with an avoid. I guess
that's the problem. Is that we've got avoid, and if we can't avoid, we need to have another policy that supports it. And the idea is that what you do then is that you have the minimum extent possible. But that's not to say that
it's pretty strict. Stern test also, isn't it?
Yeah, it may be that some form of offsetting would be allowed by the Supreme Court, particularly if it creates, it depends on what it does in terms of the relationship between the policies. Because if it says that this policy is so important that it can't be avoided, but there has to be something else to compensate, well then certainly what you're suggesting is right in the ballpark. The answer is we don't know what the Supreme Court's going to say.
Yeah.
But I would agree, if it's permissible, then that would be a logical thing to do because it is.
Yeah, okay. Well, we'll wait with bated breath on this.
But certainly it would be an easy reword to just reference the effects management. Right?
Okay, thank you.
Any questions?
I just want one piece of administrative clarity really from you in terms of looking through your appendix. You've got a highlight in relation to the hazards and the bell passages on pages 14 and 15.
Yeah, so this the yellow highlighting is stuff that's changed from my earlier evidence in chief appendix. So that's the one that I talked about where because if you so on pages 12 to 13 I've got those suggestions where I'm trying to put some of these written exemptions.
Yeah.
That this risk assessment and the land-based hazard stuff doesn't apply if you're in a coastal hazard risk. So that then the coastal hazard policy is the policy that you assess it under. So in order to address the concern that Mr. McClellan had, that there could be a fault line in the coastal hazard area, I've added that there's a need to mitigate any other hazard risk when you're looking at your coastal hazard. So that's a new consequential amendment to respond to Mr. Clallan's response to my amendment.
Yep, good as gold. Thank you very much. Thanks, Mr. Rand. Okay. Which you're hearing. Thank you. Hopefully the Supreme Court experience. Yes.
Mr. Cameron is online too.
I've got a Cameron Selson, and we've got a time issue this morning, and we have to be completed really your presentation by 11:30. So we've got an hour, and so we'll leave it in your hands. But Mr. Cameron, I see you've got a very long set of submissions. We've had a fair go at hearing from Kaitahu over the period. Certainly won't someone stop you and start to abbreviate your submissions as much as you can. Thank you.
Certainly, Mr. Chair, and that was my intention. I don't intend to read verbatim from these submissions at all. In fact, I will just touch on the key points because I know the people you'll want to hear from are Mr. Ellison, Ms. McIntyre, and Ms. Bartlett, and less from me. So be that as it may. Just starting at page 1, of course, these submissions are filed in support of the Kaitahu position on the non-freshwater parts of the land and freshwater provisions of the RPS. At paragraph 2, I just note that the division has caused some complexities, additional complexities to this process, which are set out in more detail in the written submissions. That's a matter that Kaitahu wishes to put on formal record. It's not something that I will address in any significant detail today, but these are concerns regarding the division between freshwater and non-freshwater in attempting to give effect to the High Court judgment that have been expressed by Kaitahu for some time. They will not be unfamiliar to the Regional Council or its legal team. They may be unfamiliar to the commissioners, but again, really the purpose of setting those out in the submission is just to put them on record in terms of the Kaitahu position in that regard. So moving very quickly to paragraph 5, these submissions address the legal issues that arise out of the evidence, and in particular the requirements in relation to the role of takata whenua under the MPSFM, the role of Te Manawa Te Waia, and I do want to spend a little bit of time interrogating that concept and the case law, because I think that is important when it comes to your consideration of the provisions. So that's where I will spend the bulk of my time this morning. Very briefly, some further comments on the use of Māori land and the relationship with the National Policy Statement on highly productive land, and a related point being the ability to discern between and prioritise different forms of primary production under that National Policy Statement. So over the page to paragraph 2, and really it's page 2 and pages 2 to 4 are where the Kaitahu position on the split is set out in more detail. In very, very broad terms and a brief summary, in my submission, the Regional Council, in endeavouring to do what the High Court required of it, has landed at an overly simplistic interpretation of its findings, which have resulted in a number of, for want of a better word, anomalies in terms of the way in which certain provisions have been passed out into either process, and an approach which does substantially sit at odds with the Kaitahu perspective of integrated management and kia ora ki tai. One alternative approach which could have been adopted but was not, was to simply say that if there were provisions that were required to give effect to the national policy statement, that they should all be treated holistically in the one process. As it happens, we've gone a little bit more fine-grained than that, but that has not removed the complexities. So over the page to page 4, and I'm here talking about paragraph 19, I just list very briefly some of those key concerns: the exclusion of references to integrated or holistic management, the apparently indiscriminate division of issue statements, objectives, policies and methods relating to Te Manawa Te Wai between the two processes, an issue in relation to soil management and how that fits with freshwater quality, and also exclusion of key definitions. I want to note the suggestion of council for the Regional Council that this can be remedied through hitting pause on recommendations until such time as the Freshwater Hearing Panel has reported back. I want to acknowledge that that goes some way, but it doesn't cure the requirement for planners in particular in the interim to moonlight as contortionists and trying to work out exactly what revisions and what versions of provisions they're talking about between the two processes. That's all I wanted to say. The rest is in the written submission and is there as a matter of record. Over the page to page 5, and this is where I start talking about the role of takata whenua under the MPSFM. At paragraph 22, I summarise the evidence of the Kaitahu cultural witnesses in relation to the centrality of why, and I'll leave Mr. Allison to talk to that in more detail. I do say that the importance of these issues to Kaitahu is reinforced by the policy direction in the National Policy Statement, and I list some of those key directions below. Turning over the page to page 6 and interrogating here a couple of issues in relation to mana whakahaere, one of the 6 principles of Te Manawa Te Wai. There is a suggestion in the Section 42A report that reference to the environmental, social, cultural and economic relationships that Kaitahu have with water bodies be removed, and that the focus should just remain on a more narrow subset, or in particular the cultural relationship. At paragraph 25, I just simply note that the relationship of Kaitahu with water bodies is not purely cultural and extends into those other realms. And if the words that are sought to be deleted are removed, there is a real risk that the expression of Kaitahu rakatirataka in policy 2 will be diluted, as Ms. McIntyre suggests. And I say that the wording proposed by Kaitahu, which I anticipate Ms. McIntyre will talk to in more detail, is consistent with the overarching emphasis on environmental, social, cultural and economic wellbeing in Section 5, which applies to Kaitahu just as it does to any other submitter. At paragraphs 26 and 27, I note the evidence of, in particular, Dr. Freeman for ORUG and some of the other primary production parties seeking to remove reference in that policy to giving practical effect to rakatirataka and to the active involvement of mana whenua, and seeking to limit their involvement to decision-making processes rather than freshwater management more generally. The concern seems to be that the way that policy is drafted, in Dr. Freeman's view, will lead to Kaitahu being a potentially affected party in all resource consent applications. That's certainly not Kaitahu's interpretation. But what we do say is that the amendments that have been proposed would fail to give effect to the NPSFM. The requirement for active involvement is embedded in policy 2 of that document, as is the reference to freshwater management more broadly. Turning to Te Mana o Te Wai, and I mean, this will be familiar to you all, and I'm grateful to Council, for the Regional Council, for touching on this in his opening legal submissions. So again, I won't trot over old ground, but it really underpins, in one sense, what Kaitahu have been saying throughout this process, which is that first and foremost, the health and well-being of the wai, the freshwater and the ecosystems that support go first, and that is consistent with a Kaitahu perspective. At paragraph 29, which is over the page on page 7, I note the Environment Court in Aratiatia, which is a lengthy decision but includes some very useful commentary on at least the forerunner of Te Mana o Te Wai to this document, representing a significant paradigm shift in freshwater management, observing that while Te Mana o Te Wai is not a Māori-centric but a water-centric approach, it benefits all New Zealanders, and it sets out 3 key understandings. And just very briefly, the first understanding being that water bodies themselves must be in a state of hau water before use can be considered, that being the implication of the first understanding. And the mauri and hau water of water wai is therefore expressly linked with its use. The second key understanding, this is at paragraph 33, being that the health and well-being of water are placed at the forefront of discussions and decision-making around freshwater management. And I'll touch on, it's unusual for me to be going last, so I get to briefly touch on some of the things my friends have said, which has not been something I've been able to do previously. But I do say that where there is a difference between the approach that Kaitahu are taking, and in particular some of the primary producers, it comes out of trying to come to grips with this change and putting the mauri and the health and well-being of wai at the forefront first, and perhaps a bit of inertia about the speed with which those changes are required. And I say that's reflected now in the sole objective and the requirement first to put the health and well-being of water bodies and freshwater ecosystems first. Finally, and this is the third key understanding at the bottom of page 7, that in making it, where the NPSFM previously made it clear that in using water, the health of the environment, the water body and people must also be provided for, which puts positive obligations on people under the resource management system. At paragraph 37, which is over the page on page 8, I refer to 2 decisions again out of Tiatia, where the court noted that the usual RMA focus on the scale and significance of effects of resource use has now been redirected onto the mauri or life force of water, and the inquiry becomes how do users of resources protect the water's mauri and health. And at paragraph 38, I cite the Planchage 7 decision, which again, while lengthy, is worth considering, where the court held that under Te Mana o Te Wai, the choice between the health and well-being of water bodies and freshwater ecosystems on the one hand, and the health needs of people or their social, economic and cultural well-being on the other, is now a false dichotomy. And that in my submission is a paradigm shift. Just at the bottom of that page, at paragraph 41, and this is where I touch on the submissions made by Mr. Page for some of the primary producers, where I interpreted, it must be said, a concern that restoring and preserving the balance, which is wording taken from clause 1.3 and the definition of Te Mana o Te Wai, it does not require that freshwater values need to be balanced against economic activity. The focus on restoring balance recognises that first, work is needed to improve the health of water bodies, and preserving that balance requires that uses of land and water must be undertaken in a way that ensures the natural balance of Te Tai Ao is not disrupted, so that if the wai is cared for, so too are the people who rely on it. And just finally, over the page at page 9, there was a suggestion in the submissions of Mr. Page that Māori as a cultural value must fall under the third priority in the MPSFM, enabling people to provide for their economic, social and cultural well-being. I disagree respectfully with that submission. In my view, the health of a water body as a first order priority must include its cultural health, and that was accepted by the Environment Court in the Plan Change 7 decision. I've included an excerpt from the judgment there, where they talk about, in particular in relation to Mahinga Kai, the spiritual essence, Māori and health of whole water bodies, and the concern that Ngā Runanga had through that process, that if you effectively relegate that concern to a third level priority, you're not giving effect to the MPSFM. And so for that reason, I say the submission of Mr. Page fails to read the MPSFM in a holistic and integrated fashion, ignores the centrality of Māori to the health and well-being of water bodies, and also fails to recognise the role of Māori in sustaining both hauora, the health of the water body, and the health of people. So it applies at each of the three priorities, in my view. Just briefly, in relation to integrated management, I appreciate this is a topic that was discussed in earlier hearings, but the way in which submissions have evolved, that was touched on by my friend Mr. Somerville, and again Mr. Page and his submissions. And it goes again to this concern that there needs to be some balancing on the other side of the regional policy statement to provide enabling policies to, in effect, try and provide a counterweight to the core environmental protection focus of that document. I've done my best to summarise both the position for those parties and the submissions previously given. At paragraph 47, my submission, it's not the role of integrated management under the guise of enabling policies for extractive and other resource intensive uses to attempt to balance or reconcile the potential for conflict by putting those uses on equal footing or allowing for trade-offs. In my view, and I think this was something we covered during the IM hearing, unless you prioritise the life supporting capacity and modi of the natural environment, you don't pass go. And that's part of the paradigm shift that's been discussed in earlier cases. Briefly, in relation to the MPS for highly productive land, that has introduced some additional complexity into the way in which Māori land may be used in the process in the future. And of course, you'll recall from the Mana Whenua hearings, the more enabling approach that's been sought by Kaitahu in relation to Māori land within the region. The concern is to avoid additional constraints that might inhibit the ability of Kaitahu to exercise the rakatirataka and kaitiakitaka over those lands. At paragraph 49, I pick up on a point in Ms. McIntyre's primary evidence that the directive nature of that document could impose limitations, and that policy 19, which requires that land-based primary production is prioritised on highly productive land, would affect Māori land at Karitana, and that's something that Matapura Ellison in particular talked about in his evidence. There is support in my submission for a more enabling approach to Māori land within the confines of that national policy statement, And in particular, I refer to clauses 3.8 and 3.9, which provide carve-outs in respect of land use and subdivision 3.8, land use 3.9, for specified Māori land, and in relation to land use to provide for a Section 6 matter. And of course, the Section 6 matter I rely on is Section 6E. At paragraph 53, I set out that in my submission, the amendment sought by Ms McIntyre to ensure that that policy direction doesn't adversely inhibit the ability of Kaitahu to lead in the resource management and the management of effects over its own land, is consistent with the NPS and in particular the Section 6E matter set out there. And finally, on this rather quick tour through the written submissions, and this is a point raised by Ms Bartlett in her evidence, there is, from the Kaitahu perspective, a need to be able to discern between and prioritise different forms of primary production under the National Policy Statement when giving effect to it. At paragraph 55, I've set out there the definition of land-based primary production. And the particular concern from a Kaitahu perspective is the establishment of permanent exotic carbon forests. And in Ms Cook's evidence, she discusses how that is transforming both natural and cultural landscapes within the Catlins. And the effect, as Ms Bartlett describes, is to lock up land that might otherwise be used for different land-based activities in perpetuity. Ms Bartlett seeks a more restrictive definition to exclude permanent forestry and make it clear that other forms of land-based primary production are to be prioritised. I've set out at paragraphs 57 the rationale for that, and some additional comments at paragraphs 59 and 60 from a legal perspective, which talk about the fact that to some extent the relief sought is more stringent than what the National Policy Statement requires. In my submission, the fact that the National Policy Statement doesn't include an express acknowledgement that regional policy statements and plans can go further doesn't preclude you from being able to impose that relief. And I've relied in particular on some guidance that's been produced in the promulgation of those documents to direct that, and that's also referred to by Ms Bartlett in her evidence. So for those reasons and the reasons set out in Ms Bartlett's evidence, council submit that the proposed amendment to the definition is both appropriate and entirely consistent with the Regional Council's duty to give effect to the NPS. Now, I'm happy to take any questions on any of the matters that I've briefly whizzed through, or hand over to the witnesses, and in particular to Mr. Allison.
Very clear. Thank you. I don't have any questions, but just to confirm an issue that you've raised around the sort of split between freshwater and the non-freshwater thing. And it harks back to the whole Kiuta Kitai approach, which has been at the key. It's the key issue, I think, for me through this whole process, and it. I think it's the real first time, in at least my experience, it's really been challenged in the way that this plan change has, because I've not seen it in quite the same stark way, sort of people having to deal with it, or you know, the various different ways that people deal with it. And my sense is that until we really get to grips with that, we'll continue to be having the same conversations, I guess. That's just the point I want to just reflect on as my take from this whole process. And I'll just leave it at that for now, but that's That's kind of been the theme, I suppose.
Cameron, your submissions are very clear. Thank you. I don't have any particular points. Thank you for some of those references, which are helpful. Yeah, thank you.
Thank you, Mr. Chair. On that basis, I'll hand over to Mr. Allison.
Sure. Kia ora, me no te kumihana, chairman, ko te katoa, mihi o te atanei. Thank you for this opportunity to present a summary of my evidence, which has been handed up, I believe, starting at paragraph 1. As I have described in my evidence, I belong to hapu whose identity is closely tied to the Otago region, from the mountains to the sea. We have had a continuous connection to the land and resources of this area and have harvested food from the whenua, the wai and the moana for countless generations. My evidence describes the centrality of water to kaitahu creation traditions, the whakapapa connections that arise from this, and the importance to kaitahu of recognising the interconnectedness of whenua, wai, Māori and the moana. When these interconnections are not recognised in resource management or not managed well, land-based activities can have a direct detrimental effect on freshwater in coastal environments and on the health and abundance of tauka species. The primary resource management principle for kaitahu is the protection of mauri. My evidence describes our understanding of mauri. Water bodies with healthy or strong mauri are characterised by good quality waters that flow with energy and life, sustain healthy ecosystems, and support mahi kakai and other cultural activities. In paragraph 42 of my evidence, I describe key aspects of the relationship of kaitahu with wai, and at 27 and 33 of that evidence, I discuss the importance of mahi kakai to the cultural identity of kaitahu whānau and hapu, and the richness in mahi kakai resources once provided by Otago's lakes, rivers, and wetlands. The mahi kakai resource is now a shadow of what our kaumātua and tūpuna once experienced. Factors contributing to this include straightening and channelization of rivers and streams, drainage of wetlands, reduction of flows through excessive abstraction of water, barriers to migration of tuna and other species, and direct and indirect discharge of human and animal effluent, nutrients, sediment, and industrial contaminants to water bodies. The degradation and loss of our mahi kakai resources has led to dispersal of communities and consequent disconnection of whānau from their kaitahu roots. Loss of the ability for whānau to carry out mahi kakai practices also affects our ability to pass on mātauraka about how to manage resources in accordance with tikaka. The principle of te mana o te wai marks a change in freshwater management that puts the focus on the well-being of our waterways. And as I explained at paras 81 and 86, objective LF-Y-01 in the proposed regional policy statement incorporates the kaitahu ki Otago interpretation of te mana o te wai, recognising the importance of mauri, acknowledging the kinship of mana whenua with the wai, and providing for the rakatira taka rights and kaitiaki taka obligations that arise from this. So the interconnected nature of whenua, wai, Māori and moana mean that land-based activities have a direct consequence on the rivers, lakes and coastal environments. The focus on Te Mana o Te Wai in the proposed regional policy statement recognises the interconnectedness between land and water in a way that has not been apparent in Otago in the past, and it will assist in addressing the current degraded state of many Mahika Kai sites in our takiwā. The mana o te wai is inseparable from the mana of the people, and our success in implementing it will be measured in outcomes for the current and future generations. Thank you.
Maybe questions?
Yeah, no questions. Kia ora, Mr. Ellison.
Yeah, thanks, Edward. I had a couple of questions that I thought were from Sandra, but they're probably better to reach it. You. I appreciate it, but they're just to get my understanding around things, and I'm not sure, Edward, if you've heard Mr. Farrell's or seen Mr. Farrell's evidence in Kotahu. This is in relation to LFY P3, the integrated management policy, the Kai policy. And a couple of changes there that were sought by Kotahu. One was adding restore into one. So recognises, sustains, and where degraded or lost restores the connections. And he suggested a definition of restore, and I want your view on whether that will pick up what Kotahu were actually talking about there. And he's recommended means to return to a state of good health, well-being, and resilience. And what they're saying is we recognise we probably can't go back to pre-human times, but if we get back there, and he did put that in the context of Maori and that as well. Does that satisfy what Kotahu think of restoring water bodies?
Alan, no, it doesn't quite reflect what we're seeking. We do want to try and emulate what our rivers were like, realising that that'll take some time, and in fact, we don't have the evidence to describe exactly what that looks like now.
Yeah.
And I think Mr. Farrell probably doesn't quite appreciate what we are seeking, restoring, in reflecting the Te Mana o Te Wai. It's to its natural ebb, flows, variances. It's the ultimate aim, but I think Mr. Farrell's suggested wording or approach would fall short of what we're seeking.
Yeah, I guess when that arose, we were having a discussion around the very things you raised, actually, the references to naturalised flows and how do we actually know what they were, but also the insertion of the word natural before connections, because that's another sort of trying to understand how that works in terms of Kotahu's view of that mountains to the sea. If you've got Clutha hydro scheme as an example on the Clutha, the water is continually flowing through that generally, but it's not a natural connection. But the thing is, they're never going to go away, I don't think. So how is that good enough to be a natural connection, or what's your view around that? That's what I'm after, really.
In a sense, those artificial water bodies are connected. Yeah. In fact, water flows in and water flows out, and so they do have an impact on downstream.
Yeah.
So we would still want to see that connection. In the definition, adding the extra definition of natural does tend to try and isolate our interests, or that what we're seeking, to those natural waterways, and I don't think that quite reflects the place, the role and function of those artificial or altered water bodies, and the influence they do still have, and the importance of them to our aspirations in terms of how water is managed.
Yeah, okay. Good. Okay, well, thanks for that. That sort of gives me a better understanding of where you sit with that, and I have no questions for you, Sandra. Thank you.
Kia ora. Edward, me kōrero pēnei a hau I nā e tonu nei. I te mihi kia tāu. Ki te ake I ngā rararu I rā wāhira I te pōtaitanga o Prince Charles. Ne te whakararu I wā tāua kawa. Nā re mihi nei kia koutou, kia ngaita. E mihi ana ki ngā kōrero katua ko puta mai I a ngaita. Engari ko tētahi ngā tino kōrero, ngā hau te kōrero. I te rangi nei. Mo te ao, I a tāua kaumātu. I nā no atu te nui o te kai. I nā no atu te rere o te wai. Ka re te tanga te tiko I roto I te wai. Waua mea katoa. E ki ana tēnei me te mana o te wai. Kia pērā no tō tāua ao. Reira, nā te mea ke te putu atu koe a muri ake nei. Ka e au e tae ki te mihi kia koutou. Nara me mihi nai nei kātika. Reira, tēnei te mihi atu kia kaitahu. Tērā taha oku. Tahu kua wahine. Reira, ka nui we rā mihi kia tāu. E te mohiro atu tāua te whānuitanga ake o tēnei mea te whanaungatanga. Tēnei mea te ao whānui. E ki ana koe I te ore te wai, ka ora tāu e te tangata. Kei reira te ohunutanga o tēnei mea te mana o te wai. Nā reira huni no tātou, tēnā tātou katoa. I just needed to do that because you're going to run away soon and I won't have a chance to really say, go and thank Kaitahu. One, for having this conversation in your rohe, but two, more importantly, for everybody to be part of the conversation in ways that 20 years ago, 30 years ago, we wouldn't have been, as you well know. I don't have actually any questions about what you said because I don't disagree with any of it. And there aren't any questions that I haven't already answered. But what I did say in Māori, for those of you who didn't understand, that Edward raised a really important issue here today that hasn't really come out in quite the same way as he's put it. And that is that in our ancestors' time, there was a lot of food. In our ancestors' time, the water flowed freely and cleanly. In our ancestors' time, people didn't defecate in the water. And there was a whole bunch of things, which is your paragraph 5 in your presentation today. And I think that's really one of the key things that we're looking at, because that's what Te Mana o Te Wai is saying. The very same thing. So if there's a message to be taken from this, that's it. We don't have it anymore. And the question, and my colleague to my left, he raised about Mr. Farrell's a statement about whether we are restoring, or I often like to say we rejoice in the fact that we can make the water healthy again, make the Māori healthy again, all those sorts of things. So I'm being a bit long-winded here, but it's my way of acknowledging that that tikanga, kaitiakitanga are important. They are really important. And I think thankfully the system is recognizing that more and more. I'm not sure we've got there yet, totally. But we've got, we've moved up the ladder a wee bit. We might have been down here before. We might be here now, but the ladder, top of the ladder is still way up there somewhere. And I think if there's anything to be taken from this plan change, hopefully, the end of it, that we can continue that progress. So when you know who tāku veru, te mea tiki a koe, ia koe te katoa, tēnā tātou.
Ko tēnei mihi atu ki a koe te rakatere mō tōna kōrero, e pāna ki tēnei kaupapa ki a tātou tika tō kōrero, e pāna ko tēnā whakaaro nui o tātou nei tūpuna, me ona mahi roto te taiao, i te wā tuatahi e mihi ana karakia atu, ki ngā atua, i tikana e rā me ngā taoka, ngā mahika kai, e tiaki ana te rā rohi moana, whenua, e rā me katoa, ko tēnā tika tō kōrero e pāna ko tātou. Ta mana o te whenua, o te taiao, ki tātou, ko tēnā te whanau kataka, i Waikanui, o tātou nei whanaunga, o tātou nei mātua tūpuna, tika tō kōrero. Nui ake i tērā kai, i te ngāhere, me te moana, me ngā aua katoa, tika tō kōrero. Engari e hari ana tō tātou nei tūpuna, kei ronga te whenua, take hea te warahi, i ngā wā katoa. E rā, i kimi ana, whai ana tērā kai, mō ona whānau. I mōhio ana, kawi ana, mihi ana, ki ngā kōrero o te atua, te tīmata ai o tēnei tīmata ai o tēnei te ao, me o tātou nei wāhi o ngā tangata noa atu ki te whenua, he whanaungatanga i Wainganui o tātou whānau hapu ki te taiao. I nāia nei, i paru ana, te nuanga, ko ngā wai, me maroki ana te whenua, kaore e kai, kaore e te tuku atu te mātauraka, i pāna o tēnā mahi o te mahi ka kai, ki ngā uri, ko e ki mai nei, o reira. Ngā mihi ana ki a koutou katoa, mōna mahi roa, i whakaronga ana ki ngā tono kōrero mai o tātou, i kawi ana o tātou nei wāwatahia o tēnei mahere. So I'm just saying, yes, in the past, people, they would not recognise the country now. Like we may not quite recognise the country if we were back in their time. And so there is that sort of, we are aware that there is massive change in this, evident by the fact that a lot of our activities are no longer able to be upheld, maintained. And the big factor for us is, in terms of our identity is being able to practice customs. It's through those we retain our mātauranga, but also pass that on and build that whanaungatanga to our whenua. So yes, the importance, like you've touched on all of those things, Ro, that is why we're here and why we carry the whakaaro, and we're so I suppose, buoyed, you might say, by the current MPSFN and the strengthening of Te Mana o Te Wai within processes. I think it's giving a more natural context and reducing the marginalisation, you might say, of a lot of those values. And that's in terms of the process where everything's split up. We're a bit worried about that and keeping an eye on that, and hope we come out the other side intact, that we haven't lost all of that connectivity, the importance of the connectivity from mountains to the sea that you referred to. And I'm mihi to you for your endurance and going through the process. I think you're the same commissioners for the next phase. So kia kaha, kia mai, kia manawa nui. It's a very important work. Having once set on the other side there.
Got it, Edward. The only question that I had of you was just that next issue of how do kaitahu down in this area view the special protection for the salmonoid species. Is that a problem for you or not?
Yeah, well, it is really how they managed to get in there, and it difficulties, and we, in terms of restoring some of those values that we talk about, yes, we'd like to see, no doubt, many more areas, because they do impact, they do drive our natives to the corner or consume them, and it's just difficult to see restoration truly occur. So that's a conversation we seek to develop with Fish and Game. We're very interested to see how they address the Section 4 responsibilities coming out of their review of their activities that's recently occurred. That's a challenge for them to see how they build those connections and relationships, but we're up for the discussions.
And Nami here, for the interchange. Ms. McIntyre, is it?
I will summarise my summary, given the time constraints.
You'll need to, I'm afraid.
Yes. I just note that I have included in that summary, just noted a few things that Ms. Boyd spoke about, but where there seems to be maybe an oversight in terms of the way what she has said has appeared in her drafting, in the appendix to her opening statement for this hearing. So I've just flagged a couple of things there that may need checking with her. I won't go into those in detail. I've written them down here so you to flag them for you.
Thank you.
I've just talked briefly about each of the sections of the land and freshwater chapter. In terms of the LFY provisions, which are all about Te Mana Utawai, I've just set out key aspects of Te Mana Utawai and the fundamental concept of entity, and I have discussed those in my evidence in chief. I don't need to remind you what they are really. Mr. Ellison has already talked about that these provisions interpret Te Mana Utawai for Otago, and the mana whenua were integrally involved in development of those provisions. So particularly in this section of the chapter, we are very happy with the direction of the section, and our submissions are really just looking to strengthen and clarify aspects, and particularly I guess in terms of some of the recommendations where we've seen that other submitters have raised points where they have pointed out that there may not be clarity, then we've tried to address some of those. And Ms. Boyd has now accepted nearly all of the amendments that we've sought, so I don't have a lot additional to say on that. And I note she's also accepted the point that Mr. Cameron referred to about the reference to the economic, social, cultural and environmental, social, cultural and economic relationship of Kaitahu to the wai. So I won't talk about that as well because she's now accepted that. The one point that Ms. Boyd raised in her opening statement that I do need to comment on, I think, is she invited me to explain why in the explanation to LFY provisions I had asked for deletion of, I guess, definitions, one word translations in brackets of a number of te reo terms in that explanation. So I'll just talk a little bit about that. In my evidence in chief, I have discussed the approach that Kaitahu has taken to use of te reo in the RPS. I consider it problematic to reduce cultural concepts such as kawa, tikanga and Māori to definitions of one or two words. Those terms are explained in a more rounded fashion in the mana whenua chapter, and that rounded gives people a much clearer understanding of them than a one-word explanation would. Atua and tupuna are also explained by one-word explanations in this part of the plan. While those are not similarly explained in the mana whenua chapter, I'm not convinced that a definition is necessary in the context in which they're used here, which is essentially the explanation to the LFY provisions is essentially narrative that was developed by mana whenua to explain their interpretation of Te Mana o Te Wai. And I think in that context, as essentially a mana whenua explanation, I don't, that is about the relationship of mana whenua to the wai. I don't think that there is, I'm not sure that it's appropriate to include that sort of a one word explanation there. The remaining term, which is defined in brackets, is why. That is used many times in the RPS, and I think it's widely understood, so it seems odd to just translate it in this place. The other point in terms of the LFY provisions I just want to remind the panel of is the points that I've made in my rebuttal evidence in respect to the evidence of Dr. Freeman for ORAC and other parties, and Mr. Freeland for DCC. They have proposed amendments that I think would not give effect to Te Mana o Te Wai and the NPSM, in particular those key aspects of Te Mana o Te Wai that I've pointed to in paragraph 2 of my summary. In terms of particularly the amendments to LFYP3, Dr. Freeman has proposed that it be deleted, and Mr. Freeland has suggested a sort of an exemption for integrated management for circumstances in which there are infrastructure needs that might not be consistent with the well-being of coastal waters. I note Commissioner Kirikiri's comments before about the importance of getting clarity about what integrated management means. I consider that LFYP3 is a very important provision as part of the Te Mana o Te Wai provisions to make sure that people are very clear about what integrated management means in the context of Te Mana o Te Wai. Integrated management is something that has not been dealt with well in terms of management of freshwater in Otago in the past. And so that's why I support the full description of integrated management, what integrated management means in LFYP3. I guess the other, in terms of LFYP4, Dr. Freeman has asked for replacement of the current provision with a provision that talks about providing for a transition to achieving the visions, and particularly talks about minimising the economic, the effects on social, cultural and economic well-being. Minimising those effects is not something which the NPSFM provides for, and so I don't support that amendment. And I note that it would actually constrain this ability to consider the costs and benefits and the effectiveness and efficiency of provisions in the land and water plan process, which would be entirely inappropriate. Moving to the LFW, freshwater provisions, the main point that I want to flag here again is the requests that Kaitahu have made that relate to emphasising the importance of providing for the natural behaviour of water bodies, and Mr. Allison has already referred to that this morning. Dr. Freeman and Claire Hunter have suggested removing some references to that, and I oppose those essentially for the reasons that Mr. Allison has discussed this morning. Ms. Boyd has also asked for clarification of a point, a request that we made to refer to the contribution of riparian management to natural flow behaviour, and I just wanted to clarify that a little bit for the panel. Essentially, that point is intended to provide for consideration of the way in which management of riparian margins can affect the ability of natural flow behaviour at times of high flow. So erection of structures in the riparian margin or planting of invasive vegetation such as willows can constrain the flow, which affects its natural behaviour. Similarly, devegetation might also change the natural flow paths by in combination with erosion of the banks and things like that. So I think it's an important aspect of management of riparian margins that needs to be flagged, particularly in that in the context of developing district plan provisions for riparian management, where it often gets forgotten about. Also, I just briefly want to mention the issue of outstanding water bodies. Kaitahu has a difficulty with the concept of singling out only specific water bodies for protection as outstanding water bodies if that is on the basis of their cultural and spiritual values, which isn't to say that the mana whenua values of those water bodies should not be recognised, but that those values need to be recognised across all the water bodies. In my evidence in chief, I explained that every water body that has a connection to some mana whenua, so they all the values need to be recognised across the board. The criteria which were originally in the RPS, in the proposed RPS for water bodies which referred to cultural and spiritual values, have been recommended to be changed in subsequent evidence from Ms. Boyd. So they no longer referred to cultural and spiritual values, so that issue sort of went away. However, now in her opening statement, Ms. Boyd has signalled that she might go back to the notified criteria. If she does that, then I just want to point to the original submissions made by Kaitahu Kiotago and Waitahu Murihiku that means that question of how cultural and spiritual values and mana whenua values are provided for needs to be addressed. Turning to the soil provisions, land and soil provisions, I have just referred there to the question of the impact of the NPS on highly productive land in terms of the ability for Kaitahu to use native reserves and Māori land, and Mr. Cameron has referred to that and we've talked about it previously, so I won't repeat that. I've just noted at the end of paragraph 11 a slight adjustment to the wording that is in my appendix 1 to reflect a slight amendment in the wording now recommended by LRC for that, for Alice 19. Finally, I just want to very briefly just flag a couple of points that have been raised by other submitters in this hearing. The first one is the question of balance. Mr. Cameron has referred to that this morning, and I agree with Mr. Cameron's interpretation of balance rather than the interpretation which seems to be being promoted by Mr. Page and his clients. Mr. Page and his clients also talked at some length about the need for the RPS to include details on how the freshwater visions are to be achieved, including timeframes for the transition. While I understand the frustration that they have about not being able to see the whole picture in one place, I don't consider that the NOF process allows for all of that to be in the regional policy statement. It sets out a process whereby environmental outcomes to achieve the vision are developed in the regional plan process, and following on from that, the targets and timeframes for that achievement inevitably need to be part of that regional plan process as well, rather than sitting in the regional policy statement.
Thank you, Ms. McFarlane. Thank you, Ms. McFarlane. Any questions?
Yeah, no questions from me. You've covered off the questions I had on your evidence and chief and your summary. So, sure.
Thank you. I guess the only question I have is actually in relation to your last comment there in paragraph 13 around this integrated management issue. Now, we've heard from, and it was particularly Brendan Flack talked about, let's not silo things. And isn't that what that's promoting there? Because communities are a part of the environment. So how do we actually achieve integrated management if we're not looking at all of those factors when we come to managing the environment? And as we've said earlier, the environment doesn't really care about us. We care about it.
Communities are part of the environment. The focus of the MPSFM in terms of the way in which communities are part of that environment clearly puts the primary focus and central focus on the, I guess, the way in which the behaviour of those communities affects the health and well-being of the water body. As Mr. Cameron quoted a section, quoted part of the Aotearoa decision this morning, which essentially said Te Mana Otawai changes the question to how do our uses of land and water support the health and well-being of the water bodies. And that is, I think, the focus that needs to be part of the way in which integrated management is looked at in the MPSFM Te Mana Otawai land and freshwater context, is that they're enabling people to provide for their economic, cultural, social well-being is an underlying part of the Act. It's there in the background. It doesn't need to be spelt out at the regional policy statement level, I don't believe. What does need to be spelt out is how we are to give effect to the MPSFM, which is about how do we deal with the way in which people use the land and water in terms of the health and well-being of the water bodies.
Yeah, but I think that's the point. It's not dealing with that because it's ignoring it, and it's not going to flow into the lower documents. And they will argue with you that one RPE should be dealing with that because it's not solely fresh water. There's a whole raft of things it's meant to deal with.
I don't agree that it's ignoring it. and been
Well,
trying.
I'm not saying I'm agreeing with the
I've been,
legal, so that's what they're saying.
yeah, I've been trying not to stray into the freshwater planning provisions.
Yeah, well, that's difficult. Yes.
But I do note that many of those visions actually specifically have a component which refers to, I guess, sustainable, I can't remember the exact words, I think sustainable management of land and water to support food production, which clearly provides for that. I think there are a number of other areas in which there are sort of similar references made. So I think that, I think that it is clear that those land uses are recognised in the mix. I accept that they're not recognised to the extent that Mr. Page's clients would like to see them recognised. But I think they are recognised to the extent they need to be in the RPS. I think the place for spelling out in more detail the way in which the requirements of the MPSFM affect different land uses and the considerations in relation to that is the land and water plan. I know Ms. Boyd in her response to questioning pointed out that because the land and water plan process is where the details of what needs to be done to achieve the environmental outcomes in the vision is being spelt out, then it is potentially problematic to be providing broad brush enabling approaches for particular land uses at the regional plan level, when it may be that in order to address the requirements of the MPSFM in terms of phasing out over allocation, for example, you can't provide for them to that extent.
I want to ask you a question kind of around that, but I think it's a freshwater management, but I'll just say it out loud so you can come back to the next hearing. There was a suggestion around the visions and that, and that they need to drop down to sub-catchments and be a bit more detailed, which is kind of what you were talking about. It might flow into regional plans because there'll be some that are over allocated. Some I'm getting to freshwater, but you've probably heard that, so it might be for the next hearing to sort of discuss how that works.
Yeah, and if I might just comment, I mean, I have been quite heavily involved with ORC in development of the land and water plan, and those matters and those details, and you know how you need to deal with particular catchments and how you need to deal with particular land uses, and you know, and the questions of benefits and costs and where those fall are all very live discussions as part of that land and water plan process. And I recognise that Mr. Page's client, that while some of them I have seen at some of the discussions on the land and water plan process have not been so deeply involved as I have, I am confident that the sort of questions that they are raising are being considered in that land and water plan development process.
You should almost go from the MPS straight to the land and water plan. Cut this bit out, shouldn't we?
There is a little, I mean, it is a little bit sort of, there are some difficulties that arise from the fact that the MPSFM splits the process between the RPS and the land and water plan. Clearly it has created some challenges.
I think I'll leave it at that until
Unfortunately, we've run out of time, but I want to highlight two things that you've raised for me that I'll be giving a lot more thought to in the coming days and perhaps even weeks. One of them is about te reo, how we use, I mean, the issue you raised about translating one word for one, but I think it goes beyond that, so I'll just leave that there. And the other one is around values. I don't think we've really come to grips with what values mean. I mean, you talk about cultural, spiritual values, and all that, outstanding values, significant values, and I'm still looking for the other one. So I'll leave that on the table. We'll run out of time. I'll just pass back to the chair.
And I just note that that question of what are we talking about when we're talking about values is also something that is being discussed in the context of the land and water plan development.
Thank you, thank you for your comments on the visions aspect, because that's actually been very helpful in sorting my mind out on how we try and cope with that in the years. We draw attention to provisions that I don't think got much weight in Mr. Page's case. So thank you. I have no other questions. So, Ms. Barfoot, where are we at?
I can be very, very quick for you, because I do understand that you've run out of time. So I'll be rapid. I just want to note that there's a couple of paragraphs in Ms. Boyd's evidence that she presented to this hearing. Paragraph 87, I agree with her approach that she's taken to LFWP 14.3, where she's resolving a Ngaitahu Kimerihiko submission point. Just want that on record. Paragraph 90 of her evidence, I have no particular concerns with the proposed amendments to LFFW M8A, which was the method that we'd worked through in the pre-hearing process with Dock and Fish and Game and ORC around the interactions between salmonids and Indigenous species. So just flagging there on record, no particular concerns with those proposed amendments. They preserve the integrity of what we were working towards. You've already heard from Mr. Cameron around the available pathway for you in your decision making around land-based primary production and the ability to differentiate different types of land-based primary production on highly productive land. I think this is a very significant point from the Ngaitahu Kimerihiko perspective, and what we're seeing happening in the Catlins, the ability to exclude permanent forestry from the prioritisation on highly productive land is a really important matter for Ngaitahu Kimerihiko. So the discussion in my evidence, paragraphs 46 to 55, it's contained there and supported by the legal submissions you've heard today. And the resolution of the matter is offered up in my evidence, which is an amendment to the definition of land-based primary production, simply adding the exclusion at the end of that definition. And so just wanted to reinforce that that decision-making option is available to you. It has not been addressed in Ms. Boyd's evidence. So we don't have the response to that from ORC. And lastly, Ms. Boyd has not addressed the point in my evidence around the silence in the RPS on the matter of damming of water bodies. So damming of water bodies is identified by Ngaitahu Kimerihiko Kaitahu Ki Otago in the RMIA section as a significant resource management issue. RMIA Y I1, I5 and CE I1. So I noted in my evidence that paragraphs 16 and 33, there is a need for the Council to apply section 62, particularly 1D and E in relation to this issue, because it's been identified under section 62 1B. So I was just looking for a minimum response really, so that there was visibility and clarity in the RPS around the treatment of damming of water bodies. So I read section 62 as unequivocal direction that once issues are identified, then policies for those issues must be stated, and an explanation of those policies must be stated, and methods to implement those policies must be stated. So I'm noting that the Land and Freshwater chapter may address damming of water bodies by inference, but does not explicitly state how the issues of the effects of damming of water bodies are addressed. And I think that is a gap, and it needs resolving. I note that in this process, because we've got that split, so the places where you might see that come through in explanations and principal reasons, which I think is the minimum thing that needs doing here. LFYE1, LFYPR1, FWE3 and FWPR3 are the logical places where you could make reference, and some of those are entirely within this process, some of them are split between this process and the next. So we have an opportunity to lift this up again in the freshwater hearing, but I note that LFFW PR3, for instance, is entirely within this process. But I just have, there's been no commentary back from Ms. Boyd on this point, and I think Section 6, if this is not a minor matter, it's not an issue that's been raised that's of sort of minor significance. The damming of water bodies is lifted up 3 times in the Kaitahu issues of significance, so it needs to be explicitly stated how that has been carried through.
Thank you, Ms. Bartlett. I'm sure Mr. Logan will pass that on to Ms. Boyd and ensure some response, at least in the reply. Any questions? No questions? No, there are no questions for you, and thank you very much for those points. So that concludes Ngātahu's involvement for this session, but obviously we'll be seeing you in the next round of the hearings. Thank you.
Thank you.
So, yeah, we'll have just a 5-minute break, literally 5 minutes for the doc to set up. But can I just indicate that we're running on a very tight time frame this morning. I'm very grateful to Cameron and Ngātahu for abbreviating their presentations very much to let us conclude. We realistically have to be finished by 10 to 1, maybe 5 to 1. So we'll be 5 minutes and then
in relation to two questions. What's the difference between protection and maintaining?
Oh, excellent.
And how do we accommodate section 104 1AB? Now, those submissions are lengthy and detailed, and I'm in your hands. I don't need to.
No, look, I was expecting those to come in writing, so would be read in writing. So thank you very much for that, and I'll read that with interest.
Great,
Wellington's
thank you.
like 4 hours away.
Good luck. I should also add that Mr. Brass has provided some speaking notes in relation to those questions that he will also just render and take as read.
Okay, thank you.
So in relation to the land and water chapter, my submissions are in 3 parts. I'll introduce the witnesses. I'll talk a little bit more about the legal framework that you're working within, and I will address in hopefully a reasonably pithy way the detailed submissions that the Director General has made. So in terms of evidence, the following witnesses will appear today. Dr. Richardson for freshwater ecology, Bruce McKinley for terrestrial ecology, and Mr. Brass in relation to planning. And I'll actually tender Mr. McKinley first. In relation to the legal framework, the Director General endorses and adopts the legal submissions that the Regional Council made on this chapter. The only additional matter that I wish to draw the panel's attention to concerns Te Mana o Te Wai and judicial pronouncements on the concept. Now, as I understand it, Mr. Cameron addressed you in terms of the Southland case this morning, so I won't repeat that. But I will add a couple of more legalistic comments. And perhaps moving to paragraph 5, the MPS Freshwater Management 2020 makes the priorities and the hierarchy of priorities that the Southland case set out even clearer. Freshwater ecosystems are a fundamental concept and component of Te Mana o Te Wai. And I've set out there clause 1.35. Again, this is a legalistic submission, but the addition of freshwater to the term freshwater ecosystems in my submission removes people and human communities from the meaning of ecosystems in this context. And I should add that the structure of clause 1.35 supports that interpretation. The importance of the hierarchy is shown by its repetition as the sole objective of the MPS FM. The MPS FM uses directive language. And then the final point I want to refer to is a High Court decision. The trustees of Motiki Rohe and Moana Trust and Bay of Plenty Regional Council heard last year, wherein Justice Hinton explained the MPS FM 2020 significantly developed the fundamental concept of Te Mana o Te Wai. In short, the concept requires local authorities to prioritise the health and well-being of the water body itself before human uses can be provided for. So that's High Court pronouncements on the issue, and I was able to hear Kaitahu's submissions and answer to your questions on that and endorse them. So to address the detailed submissions, issue 1, the policies and methods in the land and water chapter, amend the wording in LF FWP 14 and add a new method, LF FW M8A. And I'll read through these relatively quickly because you have Dr. Richardson's evidence on it. The first submission is that the wording in LF FWP 14.3 concerning fish passage should be amended. The rationale for that is that while fish barriers can play a role in protecting certain fragile communities, as Dr. Richardson explains, they can also cause adverse effects in some circumstances. And so careful site-based assessment must be undertaken, hence the change in wording in paragraph 10. The revised wording reflects an appropriate policy response to the objective contained in clause 3.261 of the National Policy Statement. This revision is supported by the section 42A report writer. Now, what will be an undesirable species is location specific. I'm now at paragraph 15 of my submissions. The Director General proposes a new correlative policy entitled Identifying and Managing Species Interactions between Trout, Salmon and Indigenous Species in order to address decision-making in relation to what will be an undesirable species in a given location. That proposed policy is an empowering provision. It ensures that the correct knowledge holders are around the table and that the decision makers have particular regard to their recommendations. And those knowledge holders, of course, include Fish and Game, Kaitahu, and the Department of Conservation, because the Director General has wide-ranging statutory obligations in relation to all freshwater fisheries. I've also added that the proposed policy provides a process to assist the Regional Council in meeting the requirements under the NPS FM in paragraph 17. And again, the proposed policy is supported by the Section 42A report writer. The second issue concerns APP1 and the recognition of outstanding water bodies. Amend wording in APP1. The first point is that the APP1 should include explicit reference to the New Zealand Threat Classification System, as indeed the NPS-FM does. That's a consistent theme that runs throughout the Director General's submissions. APP1 must ensure that it responds to the significant resource management issues, as I set out in paragraph 20, particularly SRMR17. Rich and varied biodiversity has been lost or degraded due to human activities and the presence of pests and predators. In paragraph 21, I set out parts of Dr. Richardson's evidence explaining about the freshwater fish fauna in the Otago region and how precious they are, and also what threats they are currently facing. In light of that, the Director General submits that the following criteria should be added to the list A under native fish habitats. Firstly, the water body is critical to the persistence of threatened species or to the maintenance of a population with threatened status. And then over the page at paragraph 23, further criteria B should be removed from list A under angling amenity, trout and salmon. And Dr. Richardson provides the rationale for the removal of that provision in her evidence at paragraph 129. Those discrete amendments ensure that the PORPS better reflects policies 9 and 10 and their hierarchy in the NPS freshwater management. And I submit that section 7H of the RMA is adequately met by other provisions listed in APP1. The third issue, objectives in the Land and Land and Soil chapter, add 2 new objectives. To a large extent, the submissions made in relation to the objectives in the Eco chapter are mirrored in my submission here. That is, objectives have to be sufficiently focused in order to give proper direction to policies, methods, and also technical provisions in the RPS, because the immediate policy framework impacts how ecologists approach those technical provisions. Wide amorphous objectives do not provide adequate direction. Accordingly, it is critical to ensure objectives are sufficiently clear and specific. The Director General proposes 2 additional objectives, and they're set out there. Otago's land environments support healthy habitats for Indigenous species and ecosystems, and land use activities in Otago are managed in a way which recognises and protects terrestrial, freshwater and coastal values, which land use activities could affect either directly or indirectly. The section 42A report writer suggests that the first proposed objective overlaps somewhat with those in the Eco chapter. But as I write in paragraph 30, it's not so much a question of objectives overlapping as complementing each other. Complementary objectives help promote integrated management between the domains, minimise the problems with structural compartmentalisation in the PORPS. And including these 2 objectives in the land chapter emphasises the importance of considering values across domains and, of course, the values of Indigenous biodiversity across domains. Now, in relation to the second proposed objective, this in my submission is a clear expression of the Utakitai. The terrestrial, freshwater and coastal values referred to are those expressed in the relevant chapters of the PORPS, and I note the panel's comments on how difficult it is to define those values. The second objective signals, however, that indirect effects on freshwater must also be addressed, including consequential and downstream effects. so preventing a singular focus on direct effects. And this is absolutely critical. Indirect effects on freshwater, land runoff from agriculture, etc., can cause significant habitat degradation, as Dr. Richardson explains in her evidence, and as the Whangamarino wetlands disaster in March of this year sadly reminds us. The final issue concerns pest management, and the Director General's submission proposes that a new pest management policy is inserted into the lands chapter. I've set out there the significant resource management issues that have been noted in relation to pests, and also the reference to Mr. McKinley's evidence explaining why adverse effects from wilding pines must be included within a land management context. And also, we must have additional policies addressing wider pest management in the pORPS. Paragraph 34, accordingly, the Director General's submissions recommended inserting a new policy in the lands chapter to address wilding pine control and pest management, and further adding the definition of pest from the Biosecurity Act. However, it is conceded that the Director General's current drafting of the proposed policy may not accord with the NES plantation forestry, and Mr. Brass will give evidence on how the wording of the policies for pest and wilding pine management might be amended to ensure compliance with the NES plantation forestry. And I'm happy to take any questions, and apologies, that was quite a quick brush through.
Yeah, that was very helpful, thank you. And congratulations on the clarity of which is helpful for us. So as a consequence, I don't have any questions.
Thank you.
Well, I do just have one, and it's really in relation to the case you mentioned to in paragraph 9 and the context of that quote. If you look at that on the face of the words there, the health and wellbeing of the water body, well, there will never be any human uses allowed from the water body, because it's pretty easy to argue that the water body needs all its water. So what was the context of that comment?
Well, perhaps before I address that, I'm not sure I agree with your comments, Commissioner, that we'll never take any water from any water bodies. That has to be assessed on an ecosystem.
So it has to be assessed on some values humans articulate these.
Well, we could get into a very deep epistemological conversation about all ecosystem thinking has to inevitably be interpreted through human eyes, because we have no other way of doing it. But what it does mean, as Miss McIntyre explained to you, that when you're considering the uses of land, water, and also air, I suppose, it has to be looked at through the eyes of what is going to be most protected in terms of the ecosystems that are operating in that freshwater ecosystem. We can't get away from that, because we have a national policy statement, clear direction on it. We are constrained. The enabling function is constrained by the NPS.
Yeah, Mr. Page's argument around that, which will be interesting to hear in the next phase, was that, well, what the health and well-being of that particular water body will also be influenced by the human uses of that water body. That's not what this case is saying.
I haven't developed this argument because I'm very conscious that I might be overstepping the role here, and it's very hard to address part of it.
I'm not criticising, I'm just trying to understand what, was there anything else in that case around it? It'd be useful to see that case. It's probably going to be more of an issue further down the track.
Perhaps I'll provide it. Perhaps I'll provide the case to the panel, and that will assist. It will probably come up in.
I think the answer is really to take what Commissioner Cubitt has said as a challenge for you to respond to at the freshwater hearings, because it is something that is more probably appropriately addressed when you're talking about quantities, which unfortunately we can't get into at this hearing. So, but he's expressed it. It is an issue that we need to address. We would look forward to your assistance on it. So if you can come back to it at the freshwater hearings, that would be very good.
Right. Thank you. So unless there are any other questions,
no, thank you.
unless there are any other questions, I will tender Mr. McKinley. He doesn't have a statement. If you have any questions in relation particularly to the Wilding Pines issue, he's available for questions.
Good. Well, I'm the one who's kept raising this through these hearings. So if I can pick up, in essence, yesterday we heard basically from the production forestry people saying that radiata is not really a base source of wilding pines, and I must admit, I better keep quiet as to what I think, but I'm interested in your thoughts on that general proposition.
I could take you to some places, and thank you for the question. I could take you to some places in Otago where radiata pine is escaping out of a hedgerow or forestry lot into montane landscapes.
Right.
So, so I guess I disagree with the proposition.
Yeah, as a general proposition, what he was suggesting was that you had a tight cone, a heavy seed, and that it was not therefore likely to be a wide spreader in comparison, say, with, Douglas fir or others.
I can show you examples where it's escaping, and I guess the issue is it's not from a production forestry; it's actually from a woodlot or an on-farm forestry or hedgerow, windbreak. So I think that the species of conifer which have very widespread is the lodgepole pine or Pinus contorta. That's at the extreme, and you come back. So it's a matter of degree, but some species, some research has shown that radiata can move on a wind-blown vector distances, and I guess that's actually the establishment of conifers from a source to a beachhead then leads to further spread, and it's the ecological dynamic of invasion of those spaces, which is actually as much as a problem as how far they go. And because in my evidence, I talked about, being clear about what are you expecting out of buffers. And in some respects, is this question really about buffers for radiata or categorizing certain landowners into part of the problem? Because, I think, and the NPI advice in terms of the National Conifer Strategy is it's a site-based, the right plant in the right place, or the right species in the right place. So, production forestry in coastal Otago is not going to be a major source of Pinus radiata. I can get that. But in the montane valleys of the upper Manahira or around Queenstown, it clearly is.
The general proposition that was put to us yesterday that the inland areas are unlikely to be planted in production forestry because they're either too distant or too dry. Any reaction to that type of generalized description of the more central parts of Otago?
Well, I think it's very difficult to draw a general proposition because the face of forestry planting, the face of conifer planting in New Zealand is changing in front of us. And I remember a comment from Dr. Mike Pearson about the amount of carbon planting that's going on, the rate. So I don't think you could right now be able to say that it's not happening in the inland areas. I mean, I've been in the headwaters of the Kakanui, which is on the edge of that earlier this year, and there's big old moderate hill country sheep farms have been converted.
In the headwaters of the Kakanui.
In the headwaters of the Kakanui.
Right.
So, so it's a legitimate change, no problem with that. But if you go further west, it's drier and it's harsher for conifers. But in the Queenstown area, the conifers have done extremely well. So I'm not quite sure you can say that the climate in central is such that you can't plant there, because we know these trees do grow there. They might not grow as fast, but I don't think you can draw a generalisation about the coast versus the inland in terms of conifer plantings.
Right. And you certainly couldn't for carbon forest planting.
Yeah, so that was a specific point that you raised with us when we last met. And so I did go away and do some digging on that. And I'll come back to you with an analogy. When you have a paddock, you can map it with a remote sensing tool like the land cover database or other tools. So it's a paddock, it's covered in grass, but you don't know if it's a sheep paddock or a cow paddock. Similarly, when you map forestry, it maps as forestry, but the purpose for which that forestry might be applied is not revealed, and it can change. So the answer is there is no repository or central figures of what has been planted for carbon farming.
Okay, thank you. Those are my questions.
No, I didn't.
Thank you, Mr. Gunnar.
Thank you.
I'll invite Dr. Richardson. She has a very short statement which she's provided. She's just going to read her headline points from that, given the time pressure.
Maybe we'll get Solomon's slide show next one.
Yeah.
So just following some of the discussions and questions I've received, I thought I would try to provide the panel with some reflections. And I don't have so much issues as in the legal submission. I have key points.
Sure.
So the first one about climate change. In my opinion, it is not the highest current threat for freshwater biodiversity and ecosystems, although its effects compound and worsen the impacts of current threats. Therefore, the pORPS should provide a planning and policy framework for future climate-related threats and issues, but it should also address current pressures that are made worse in a climate-changing context. So I basically discussed the sixth mass extinction of biodiversity in this to illustrate this point. Second key point, protection of fragile and charismatic species and habitats must be ecologically, economically, and socially viable. This was to address Commissioner Kirikiri's question about why do rare species matter, and expand a little bit on that discussion. Third key point, however, given key point 2, the effects of human activities on all ecosystems and indigenous biodiversity must be addressed holistically. And this is a point that Mr. Brass will develop in his submission as well. Fourth key point, instruments such as the pORPS can drive cross-sectoral approaches that assist in managing freshwater values and move away from harmful policies. So last time the panel asked me for my opinion regarding how the RPS could be improved in general terms, and these are my reflections on that question. And I'm ready for your questions on the freshwater chapter.
Thank you.
Yeah, no, thank you. I don't have any specific comments on your evidence, but we'll read this with interest in detail at the airport.
Thank you.
Yeah, no, thank you.
No, thank you. I don't have any specific questions, but I think probably some of your evidence will relate to some of the changes that Mr. Brass is probably addressing in the APP1. And so maybe that'll be a team issue. Thank you.
That's fine.
Is your caption correct at page 3? Nearly the entire range of pupfish is available, is visible in the photo?
Apparently, yes. Yeah. Well, no, that's the entire range. It's about 20 meter, long.
Right.
It fits 4 to 5 scientists.
based on the photos.
More than the public.
This is meant to, provide a mirror with an overseas experience of similar issues that we are facing in New Zealand.
The only question I had for you particularly was something that I was unaware that eels might, until yesterday, we were told that eels can be a threat to galaxids. Is that correct?
They prey on them.
Oh.
Yes, the galaxids are a source of food, and eels are predators. Historically, they used to be removed because they threatened ducks, and duck hunters didn't like them. So it's not so much a threat as a natural predator.
Yeah.
And yes, that's the case. Koaru as well in some areas are considered undesirable, and there are anti-trout and koaru barriers to prevent their incursions into some non-didermous galaxid habitats. And I'm a little bit, this is a bit of a mind, like torture, because koaru are in their native range and they are an at-risk declining species. However, in some areas where there are even more vulnerable species, they might cause problems. So that's the case for eels as well.
Okay, thank you. And similarly, I think I'm going in my bag to read at the airport as well. So,
hopefully it's a little less dry, no pun intended, than
thank you very much.
submissions.
So we'll turn to Mr. Brass to see how he pulls it all together.
So following the last hearing on the EcoCheck, I've prepared two sets of speaking notes. One is a follow-up from the Eco hearing on points that were raised and questions of the panel there. Now, to a large extent, that sits with Warnock's legal submissions which you've received. But with your leave, I may just take probably about 1 or 2 minutes to quickly cover key points there. So first, paragraph 2, I consider that protection is a narrow and strict defensive action which sits within a broad range of actions that make up maintenance. At paragraph 4, I've given some indication of the wider things that I would see as fitting within maintenance, which include but also go well beyond just protection. And I would make the note at paragraph 7 that protection in terms of particularly section 6C of the Act and into CPS policy 11A, that protection is targeted at quite specific values, locations, so threat species, critical habitats, those sorts of things. Whereas the maintenance function of regional councils under section 31 GA, that is at the level of a regional function. So in my view, that supports that protection is, if you like, a narrower, more targeted element of maintenance, which can be a lot broader. In oral discussion, I briefly mentioned protection of tussock, and I've just included an example there, paragraph 9 in the Dunedin City 2GP, where there is allowance for larger clearance of common species than for other species. And I just confirm that I'm comfortable with that approach, and I wouldn't see the RPS leading to an outright protection of tussock that makes farming impossible in those areas. There was quite a bit of discussion at the Eco hearing regarding policy P6, which is the effects management hierarchy. I do go through at 11 some reasons why I think that hierarchy is not necessarily as restrictive as has been described by some other parties. Certainly in my experience, I think that most activities within Otago would be able to get their way through there. But I do want to just draw your attention at 12. At the hearing, I just made an oral suggestion that in terms of how people would see that being implemented, there is usually that offsetting and compensation when you're dealing with residual effects, that you wouldn't kick that in for residual effects. I think I used the terms minor or transient. I'm suggesting their wording, which would align with the MPSF in 2020 and also with the exposure draft MPSIB, to add in it clause 4 where there are more than minor residual adverse effects. So the way that that would work is that for any activity, the first sets of the effects management hierarchy would still apply. Essentially, that's avoid, remedy, mitigate, which we're told to do under the Act regardless. If the effects were transitory, less than minor, then they could be considered as part of your standard 104 consideration of the activity, and you wouldn't need to go through to offsetting and compensation. And in particular, there's concern at the bottom of that hierarchy is if you can't do any of that, then you avoid the activity. I don't consider that that's for avoiding the activity as either required or intended for minor effects. So the intention of that word change is to make that explicit. And at 14, with that change, I've then gone through some examples of activities from the small to the large and how they might make their way through. Probably just skip then through to paragraph 18. In my evidence in chief, I supported Ms. Mealy in suggesting that some elements of the appendices dealing with offsetting and compensation could have provisions that essentially acted as drafting gates shifted to being policy. So I have in my appendix 1 attached some proposed wording for doing that. That was asked for at the hearing. And then just the other point is at 21 and consideration of section 1041AB, which specifically allows for consideration of offsetting and compensation. So I support the legal submissions and consider that even where a proposal didn't meet the requirements of Act 3 or Act 4, that it could still be considered, but it does then become a matter of weighting that can be applied to it. But that's going to be context, circumstance specific. So, as I say, that's responding to things that came up from it here, and also a number of things that I've given orally that I thought it would assist to have in writing. Questions on that, I'm happy to deal with that now or skip through to land and freshwater.
Look, I do just have one question that relates to that word transitory, and I noticed your comments in paragraph 13 that transitory would not normally be more than minor. We've just had evidence from Port Otago, which makes me think that there would be potentially a transitory effect arising from their dredge depositions, which will actually be quite significant in immediate effect, but transitory. So wouldn't that suggest that one would need to have in minor or transitory?
I wouldn't support that, because if a transitory or short-term effect is very significant, then I don't think you should be ignoring it for the purposes of this policy. So if with, for example, Port Otago's dredging, if it's having significant adverse effects, then I think that you should be looking at offsetting and compensation. Part of that will be what are the ongoing effects of that. So if, for example, it's going to cause significant discoloration and sedimentation, but within a relatively short period of time, that would have naturally recalibrated, then that would go to, if you like, how significant that effect is. So the transitory nature becomes part of the consideration of how significant those effects are. But if, for example, during that transitory period, it was going to smother a seagrass bed, which was not going to be able to recover, then I wouldn't see that as being appropriate to be cut out from the policy. If it was something that was going to quickly recover and not cause any ongoing effects, then that would be less of an issue and could either be possibly considered not to be more than minor overall, or if it is relatively short term and not large, it's going to be more easily offset or compensated for if you do take it through that gateway.
I suppose the devil's advocate would say, though, that if it was to have a smothering effect on a grass bed, that seagrass bed, that it wasn't transitory.
Well, yes, yeah, exactly. So that would all be part of what would have to be considered. So if it was truly a transitory passing, and in 2 weeks' time you have no way of telling,
and you say that's minor.
Yeah. Then I would struggle to see that as being more than minor.
Yeah, right. Okay. Any other questions on that? Sorry.
Yeah, just one question on your Eco P6 that you've got on the back page there. So you're amending at the top, avoiding activities that will result in. I'm just trying to make that make sense with 4. Wondering if you can help me. You're saying avoiding effects that will result in, but 4 seems more to be, 4 is going back to an effects management hierarchy, which isn't really anything to do with avoiding or with resulting in a certain effect.
Actually, fair point, and I'm just looking at the.
And I was just trying to think of sort of wording that might kind of get around that, but you've probably got your head in the policy a little bit more at the moment.
An option would be to make that avoiding activities, making that 1, and you could then have 1, 2, 3 as ABC.
Yeah.
And then subject to 1 above.
Subject to 1A. Yeah.
Do you want to recast that and send it to the hearing?
Can do. Yeah.
Thank you.
Yeah, it was actually along similar lines, but I haven't read all this yet, Mr. Brass, but I know you make sensible suggestions, so I will be giving a read of it. But just in your paragraph 14A, removal of a single Matagari, in fact, the issue raised, are you saying that they have to get consent? Because I know for sure that farmers won't.
No, so that would
get granted consent, they're not going to apply.
So that would be the first thing. And sorry, going back to my discussion on maintenance versus protection, if it's not something where protection applies, then maintenance, in my view, does allow for example, permitted activities for certain areas of vegetation clearance, for example. So no, that removal of a single Matagari would only be an issue if, for some reason, a consent was triggered.
Oh, okay. So because that's where I was getting confused. Just when there's no barrier granted consent, what you're actually saying is that it may actually be a permitted activity to do some of that stuff, like tussock. Yeah. Okay.
Yeah. So just, I guess my point is that you're only going to be applying Eco P6 if it's in a consent process. For some reason, I would not expect removal of a single Matagari.
That's why I prefaced my comment that you always make sensible suggestions, and then I saw that. I thought, what's he doing? Thank you.
Oh, sorry.
No. So, in terms of the LF chapter, I'll start at paragraph 2. In my evidence in chief, I propose that 2 new objectives be added to this chapter. provide a clear connection between management of land within this chapter and provisions elsewhere in the proposed RPS. And I've set those out there. In Ms. Boyd's opening statement, she considered there could be some merit in the first, with some concerns and questions, but opposed inclusion of the second. So I've reviewed my first proposed new objective against the existing LFLS objectives. I consider that the new objective would provide a terrestrial counterpart to the existing LFLS 012 for freshwater, but it would be clear to retain them as separate objectives rather than trying to combine them. I do also consider that there is still merit in the second proposed new objective, as it would provide a clear signpost connecting the LFLS provisions to provisions elsewhere in the Target Regional Policy Statement, rather than just relying on signposts from those other places back to this chapter. I might also consider it would provide a clearer framework for changes that I propose in terms of wilding, conifers and pest species. So turning to that, Ms. Boyd's opening statement, she agreed that the impacts of wild and conifers were broader than only biodiversity and natural features and landscape, which are the policies currently in the pORPS that address wilding. She did, however, have concerns with drafting that both myself and Ms. Bache for Insula 1 had provided, but she didn't provide alternative drafting herself at this stage. So, as has been noted, take the point about the impact of the NES plantation forestry and resulting need to separate out provisions relating to plantation forestry versus other plantings. Ms. Boyd preferred Ms. Bache's drafting of the new policy, so I've looked at that and suggest that plantation forestry, which is permitted under clause 10 of the NESPF, could be excluded from clause 1, which would avoid conflict with the NES and would allow clause 1 to continue to apply to permanent forestry, woodlots, windbreaks, etc. And just from the comments from Mr. McKinley earlier, it is clear that there is an issue there that needs to be addressed. For clause 2 of Ms. Bay's drafting, I do not consider the summer exclusion as required because the NESPF allows rules and plans to be more stringent where they're developed to give effect to the NPS-FM. And I do have drafting attached as Appendix 1. However, Ms. Bache's drafting simply requires that wild and conifers be managed and does not set any purpose of outcome for that management. As has been discussed previously, wild and conifers can impact on a wide range of land values. So I consider that there is still a need to have a policy relating to those wider effects, and that the land and soil chapter is the logical place for that. In my evidence in chief, I proposed a new policy, LFLS-BX, to address this matter. I'll discuss the drafting of that further below, but consider that a policy along those lines would be appropriate to sit alongside and prior to Ms. Bache's draft policy. The structure being that first policy would deal with reducing the effects of pest species in general, and that the redrafted version of Ms. Bache's would then deal with the specific issue of planting and establishment of wild and conifer species. And just in terms of that drafting of such a policy, Ms. Boyd considered that the original drafting was too broad. Having reflected on that, I considered that the key aspect I was looking to cover was that the pORPS enables control of general pest species rather than requires it. And I think that's important because that then flows through to regional and district plans and provisions that, for example, permit removal of pest vegetation or allow use of pesticides and herbicides even within SNAs or regionally significant wetlands. I just note that those are current issues limiting the ability to control pests within Otago. Such an approach would not duplicate the Biosecurity Act, which is a concern of Ms. Boyd's. So it would be the primary legislation for requiring control of pest species. But those provisions would support the implementation of that by enabling pest control activities, not so much through the RPS, but from what that then leads to in terms of district and regional plan provisions and particularly rules. And at 10, in terms of wild and conifers, I know that this approach will also ensure that the pORPS doesn't just manage new planting and establishment of wild and conifers, but also provides for control of wild and conifers which have already spread. There is a need to deal with the existing problem, not just prevent new problems being created. So as a note, I have proposed drafting. I won't read paragraphs 12, 13 and 14. There's simply noting my agreement to Ms. Boyd's drafting on fish barriers and species interactions. So I hope that's been reasonably left a little bit of time. If there are any further questions, happy to take them.
Yeah, and I thank you very much, and thanks for the, you've obviously put a lot of effort into trying to address the officer's concerns and come up with something useful, so that's great. One question, and I'm trying to remember, going back to the eco chapter, whether you were one of the planners suggesting broadening management of conifers out to wilding tree species. I'm sorry, I'm having trouble remembering.
If I suggested it, I don't recall it.
Yeah,
I do
so,
know.
so some have, and I suppose we're talking sort of sycamores and various other things. But if we were to go along that line for the eco chapter, do you think that this one, your proposed P24 would need to be broadened to reflect that as well, or are you? I mean, I'm looking here at sort of, purpose of forestry, landscaping, community gardening, erosion control, and shelter belt planting. So so this is more looking at managed, planted, intended to be there type trees. Am I right in that?
Yes, it is. So it is very much a subset. I would just make the note, and I'm not the ecologist, but my understanding is that the appendix, I think it is rather than a schedule, of wild and conifer species in the books is not actually limited just to conifers. There are some other tree species there. So that may be a case of lining up the wording.
Yeah.
But I do think, it could be useful to broaden it that way, but that what I'm now proposing is P24 is really quite specific to the sorts of trees that are deliberately planted in reasonable numbers. There are not just trees, but a wide range of other pest species and not just plants. There's fauna pest species as well.
Yeah.
So I do think there is still a need to have that much broader policy regarding enabling pest control.
Yeah, no, thanks for that.
Yeah, thank you, Mr. Price. Your supplementary evidence dealt with the pest issue for me, but I'm not sure if you've seen some games evidence that was presented yesterday on APP1.
No, I haven't, sorry.
Oh, okay, so it wasn't just on APP1, it was also on that new method MA8. They've just recommended some changes to that, which in your view would be quite useful. And I can't compare these to Ms. Boyd's changes because I, for some reason, don't have them in front of me. And there 2A, they added, it's AA actually, describe the physical habitats required to provide for the protection of Indigenous species. I think that may have come in by Ms. Boyd's recommendation to it.
Yes, that's correct.
Yeah. So then it reflects there's A and B are actually the same as your A and B. And then C is recommending C3 taking out the references to what you're promoting, including measures to manage adverse effects on trout and salmon and Indigenous vegetation. Biodiversity, basically, I think on the basis that, well, this is what the whole method's about. was there any specific reason you requested that? What was the reason you requested that?
That's really about clarity. That does go to the heart of why you would bother having this policy at all. And it's really about making sure that that is expressed clearly within the policy.
Yeah, and he's also recommending retaining subsection 4, revenue 4, which is the tools available in those other acts. I think maybe from memory you're recommended they go because that legislation may change.
No, certainly in my view, that's worth retaining. Ms. Boyd recommended some changes, so rather than being a directive, use these specified tools.
Yeah.
It's more of a consider the use of a range of tools such as, and I'm comfortable with that. I think given that the tools may well change over time, having that broader wording is probably appropriate.
Okay, because in your evidence in chief, you'll remove that, so you'll change your position on it. That's fine. And just in APP1, Dr. Richardson may have a view on this too. There's just some changes recommended on that criteria that I'll be interested in your views on. And the ecology habitat for trout and salmon B, recommending there, well, first referring to salmon, cutting out a few words, but supports in part or in total a self-sustained population of salmon in part or in total. So I had a question of him that's very broad from a species issues in the interaction between native and introduced. What is your view on that change? Because that would, I know they have to meet all three there, three of those criteria, but that just about brings it out to every water body in Otago.
I have issues with Appendix 1. So I have, in general, issues with criteria that are solely focused on one type of a particular species that is incidentally non-native, or a particular group of species that are non-native.
Well, we got stuck with that because the Act says you have to deal with it in some way.
Yeah, yes. So I'll try to get back to what I proposed in my evidence in chief about around Appendix 1. I was having the reflection that, again, when I suggested edits or amendments to that new proposed Appendix 1, it was akin to like focusing on these criteria rather than the policies, and it's akin to the process we had gone through with the joint witness statement on Appendix 2. Yeah. So could you please repeat the proposed amendment while I try to find my evidence?
If you go to APP1 at 273 of the section 42, of the RPS itself. And then, it's on page 274, the headings habitat trout salmon. The current list A, B criteria supports the self-sustaining population of wild trout or salmon. The changes to the bottom bit of that are relevant. What they've added in or recommending is supports in part or in total a self-sustaining population of wild salmon. So it significantly increases the breadth of a water body that would be encompassed by that.
So what they're saying, in essence, is if there's any type of spawning activity, then it's an outstanding habitat.
It has to meet all three of those criteria, but that that's a starting point, and there'd be a lot of rivers that would probably meet that.
Yep. Yep, like well, it sounds to me as if they're trying, well, the aim is to identify spawning areas to allow the gazetting of those spawning areas. I would disagree with the statement. This is more restrictive because, therefore, in my view, better aligned with the preservation of native biodiversity. Then again, I am not aware of any example of a partially self-sustaining salmonid population.
Well, that was kind of another question that arises out of that. What does it mean?
Yeah, out of the top of my head, no, it's not. I feel like that if they're acclimatized, they are self-sustaining.
Yeah, from a planning point, I would have concerns or questions about that drafting, because I would kind of take self-sustaining means self-sustaining. And if it's partially self-sustaining, i.e. it needs some kind of management or stocking that's self-sustaining, and that.
When they indicated that, for example, the southern reservoir, the reservoirs around Dunedin that are stocked wouldn't fall in with that for obvious reason. But if you're stocking some rivers a little bit, for example, and that may apply to perhaps the sea-run salmon, maybe. I'm not sure.
Yeah, there's certainly comes and goes. The organisations able to do it or doing it, but stocking of salmon would certainly apply there, where it's supplementing a natural or a self-sustaining or established population. That does then become potentially very, very broad.
Another point about that is that if there are salmonid incursions into new habitats and spawning activity is noticed, then it might trigger all these criteria in the future. I don't think that the expansion of salmonid habitat is something that we want to encourage at this stage.
I'm sure it's aimed at that, but that was useful context, because I've been trying to work out what that meant in terms of the water bodies in Otago, because it did look to me as kind of from probably there to there for an introduced species. I didn't say peace, but okay, thank you.
I've only got one final question. It's really just probably a personal matter more than anything. There was a suggestion yesterday that by the forestry chap, Mr. Oliver, who was very straight up sort of chap that I know, he was really implying to his response to me that I was mistaken contorter for a radiata, as I was concerned about the spread through the Mackenzie country on a recent drive. Have you driven it through it recently at August?
Yeah, I was up there in January.
And were you concerned with the spread, particularly between Tikapo and Omara?
So Tekapo to Omarama includes Twizel.
Yes,
yeah, that's right. I was quite stunned at all of the changes in the Mackenzie Basin, whether it's pivot irrigators or what. And there are some places just south of Twizel along the road where there's tree lanes or windbreaks where you can see them spreading out. So yeah.
And is that radiata or is that contorta?
Sorry, I didn't get out of the car.
No, nor did I. So you probably got away with the results, but okay, thank you.
Yep. I mean, lodgepole is an extreme wind spreader. It really is extreme, and that's well known. But radiata is up there. And I mean, I think other species like the fir are where it's less. It has other major significant effects rather than just wind spread, seed spread.
Thank you very much. And Ms. Warner, thank you very much to you and all your team for assisting me in being able to get home for once, particularly when this is the last day. So I thank you all. It's been a very, and all of your contribution through the whole of this process has been valued by us and very helpful. Thank you.
Thank you. Look forward to doing it again.